No, no. কে করবে এটা?
My lord, I seek your lordship's kind leave, my lord, to mention one urgent motion, my lord. My lord, for making the toilets of the minority community, the project was of the state government, for which, my lord, I was directed to complete the said constructions. And I have made the construction, completion certificate has been given.
Payment has not been made.
DM is directing the BDO to disburse payment, my lord. BDO, my lord, on some excuse or something else is given.
I am not including these matters as urgent motion.
Otherwise, the bank is, my lord, running after me.
I understand
I am
there are a
facing
lot
the
of
surfacey.
matters, but then I cannot help.
I am
Yes.
facing the surface,
No,
my lord. I am
cannot
very
help.
difficult.
Under grave urgency, my lord, I am mentioning item number 569 of the monthly list, my lord. My lord, the urgency is this, my lord, the petitioner club has participated in B division football league, my lord. And your lordship, the association just before quarterfinal, my lord, in the quarterfinal, the club has, my lord, already, my lord, qualified, my lord. And the association illegally, by adopting unfair means, my lord, ousted the club, my lord. And we have raised objection, my lord, within 1 week or 2 weeks, my lord, the quarterfinal match will start, my lord. So, lordship, I am praying for upgradation in this matter, my lord.
No,
Or otherwise, my lord.
no, no.
My lord.
My lord,
Sir, may I permit to mention on the running hospital has been directed to stop, my lord, for implementing certain recommendation by the fire safety authority. There is a provision that you have to give undertaking that within this period you have to comply with the same. We have given undertaking, and our inpatient service has been stopped, and there are more than 220 patients are there.
which hospital?
GFC hospital at Medipur.
It's not a government hospital.
No.
And
There is a direction for recommendation
yes,
that I have to comply with this recommendation. There is a provision that because it is a hospital was there in the year 2010. This recommendation came in the year 2015.
what recommendation?
That fire safety recommendation,
Fire
the
safety.
2015. So there is a provision that if you want to implement, you have to give an undertaking that you have to do. Will do
I
the same.
understand from 15 to 25, what
Their certificate was there for the existing
period?
After that, it is not the reason. Reason is something else. There is an allegation of funding of the junior doctor.
1 minute. And what is the facility that has been withdrawn?
Inpatient admission, and they are directed to remove all the inpatients. I have already taken steps.
The OPD is functional.
OPD functioning, my lord.
Inpatients.
Inpatients, there is chemotherapy. My lord knows that and dialysis units are there.
All right.
It requires regular intervention of this intervention regarding the chemotherapy.
Where is the matter?
I filed, my lord.
Oh, you filed. Very well. It will appear Tuesday.
May I,
My lord,
Wednesday,
Wednesday.
Wednesday or Thursday, because my lord, I have to
Serve.
Kumbo and serve, my lord.
Oh. When? Thursday?
Thursday or Friday?
30th.
30th.
Serve notice.
Yes, that's right.
Urgent motion, my lord. I am an ex-director of the company, my lord, who was the principal.
No, urgent motion. Where is the matter?
My lord, it was filed, my lord, it was taken up in October, my lord. After that, it was directed to be listed, my lord, is not in the list, my lord.
Can't help.
Please. My lord, the difficulty is in the recovery proceedings,
When
my lord.
I take up matters for upgradation, please mention. It will
I'm
be
not upgrade for inclusion, my lord, it is not in the list.
Hey, inclusion also. Same
My lord,
time.
the difficulty is, my lord, the recovery proceeding, a warrant of arrest is being issued against me, my lord.
my lords, may I be permitted to mention a matter from the list of Honorable Justice Aniruddha Roy? It is a Group 1 matter. I am mentioning for extension of interim order.
When is it expiring?
It is expiring on 31st of January.
All right, serve notice upon your other side.
It is served, my lords.
My lord, may I permit to mention for inclusion, my lord, but
No, sorry, no.
Passed an order on 20th of January. One correction in the date of the RBI master circular. May it appear, I have indicated it, my lord, in this, my lord.
Let me see.
My lord, internal 2, my lord. At the top, just above, my lord, paragraph 5.
Yes.
My lord, the relevant master circular at that point of time was 1st July 2015 and not, my lord, because the order was passed on 1st of December 2023. That's the reason, my lord, the date of the circular here is, my lord, it should be, my lord, 1st July.
Today, a supplementary list will be published. It will be published there. Lordship, may I be? But then give notice to the other side, please.
Upon notice, I'll again give it.
Please. Today's supplementary list.
My lordship, may I be permitted to mention a matter, my lordship? It's a writ petition. We filed it. We are the petitioner herein.
I do not want the merits of the matter. Where is
Yes, my
where
lord.
the matter is now?
My lord, the extension interim order is expiring on the 31st of January. I am mentioning for extension of the interim order.
My lord, in this
And who's
matter,
your
I am the other side, my lord. Here, if it have already been exchanged, here the question is pending is
Let it
this
appear in the
1000
list once, then make submission.
Lordship, may I be permitted to mention a matter pertaining to my Lord Justice Aniruddha Roy list? Lordship, this is a restoration application. May it be listed at the earliest for
No.
restoration?
This is not an urgent motion,
Very well.
so you have to try before the bench taking up that matter.
No, item number 67 of today's list, Lordship, matter pertaining to the taxi stand in front of Asansol railway station. My lord, on the last occasion, in presence of both sides, it was expressed that there is a possibility of settlement. We have communicated the order. Even the railway has communicated a letter to us by responding that you may settle it. So when we have started the procedure for the settlement, now the railway authority are trying to barricading the entire thing by putting the permanent barricade. And our taxis are unable to come out from that place. Lordship, so
First,
we are
you enter
facing
into
some.
settlement, then only this can happen.
Now
Isn't
they are
it?
not, on one hand they are saying that it is being they are going to settle it. On the other hand, they have not yet responded. But we have a bona fide, we want the matter to be settled, and we are also thinking the possibility has not yet been exhausted.
Hmm.
Lordship, can it be taken up on next week or today also at any point of the time according to your lordship's convenience?
No,
So that I
convenience
can
is
bring
absolutely impossible because with so many matters, it's not convenient.
any day.
But
next
then
week, I will put on notice,
you
Lordship.
speak to your other side, the learned counsel who was there, if anything can be done.
Lordship.
Or next week you bring him, let us see what can be done.
Grateful, my lord.
Yes.
Lordship, may I be permitted to mention, Lordship, the only problem with this matter is it's a new filing, but it has come in A4 paper instead of executive bond. May I be granted leave to file it?
File it means?
It has come in A4 instead of regular executive bond paper, the petition signed from Puducherry by an 80-year-old man. We couldn't make.
What can be done? Can the court grant leave? I do not know.
Yes, once the court
Original
grants leave, this can be filed.
Because my officers are saying, please inquire if what can be done. My officers are saying it's not possible since the rules have changed. So it cannot be done.
If may I interject, there are occasions when a notarized affidavit or a petition has come either in A4 or both sides printing.
No, it was previously
allowed.
done.
No,
Previously it was done.
No, now also it has been allowed.
Which
With my
period it
lord's
was?
leave. With my lord's leave, it has been allowed.
দেখুন একটু কি করা যেতে পারে।
Leave when my lord grants leave.
Let us see if there are occasions, if it can be done, it will be done. Yes.
Villagers of the Lalgarh has come up before your lordship, my lord, against the Jalapuris have attempts to settle a ferry, my lord, where the decision being.
Why here? Why here?
Jalapuris is settling the ferry.
Group 5. Yes.
My lord, may I be permitted to mention a matter for upgradation, my lord?
No, please. Yes.
For upgradation.
No, no.
Urgent, my lord.
No,
I have
can't
my
help.
lord's leave. These are the AH Wheeler matter that will recall. Millard had sent me back to the senior division manager.
Where
to
is the
consider-
matter?
It's running in my lord's list. This is item
Let it
307.
remain.
Millard, kindly bear with me for one moment.
It cannot
Only
be done.
one moment, Millard. Millard, can you take this as a big matter only on Monday? I'll come back on Monday, Millard.
No.
Millard, the
my lord, may I be
difficulty is the adjacent stall has been granted 494 days. I have not been granted. Millard, on that basis, Millard had sent me back to the manager. But the manager has not considered, had not given a reasoning with regards to that. Has point blank said that 60 is what is I have.
My lord, may I
cannot
have my
kindly
lord's leave
please,
to, my lord, have a matter heard as an urgent motion, my lord? We've
Right.
obtained the filing number only, my lord, on 22nd, my lord. We filed it in the department, my lord. It still is yet to appear in the list, my lord. I'm praying for inclusion as an urgent motion. It's a tender matter, my lord, where, my lord, a specification that is provided in the tender. It's a railways tender where a specification is provided which wasn't certified by the RDSO at the time of publishing of the tender. The RDSO has published that specification in January 2025. Yet the tender provisions, my lord, provide for such a such a specification, technical qualification. My lord, the entire tender process, my lord, vitiated. It was designed only for a single purchase, my lord, bidder to be selected as a technically qualified bidder.
From did the single bidder get that
My lord,
specification?
because it's related to the government, my lord. That's how my allegation is released. My lord, the entire tender process is vitiated by malafidis, my lord. I'll show, my lord, the RDSO specification comes out in January 2025. The tender process is published in December 20. My lord, it has been opened. My lord, it has been opened. The work order will be issued on any date, my lord. Any date, my lord. I will take, my lord, 15 minutes of my lord's time. Only two documents.
Prior to the opening of the tender, why couldn't you come?
My lord, prior to the opening of the tender, my lord, I couldn't participate. I have written letters, my lord.
Not even
I have not participated. My lord. I have not.
I'm not including.
Kindly consider my letter.
Sorry, madam. Yes.
With the kind leave, my lord, this is original side matter, my lord. Your lordship, my lord, in respect to jute matter, your lordship has directed us to, my lord, put the payment. Now, only difficulty is that, my lord, already we have put in the payment, my lord. Monday or next week, my lord, we are having some problem. If your lordship, my lord, allows me, my lord, I can bring my other side who is appearing, Mr. Sarogi is appearing, my lord. So, in 2 p.m., my lord, if that matter can be shifted to the next week, my lord. Only this paying, this much
2
paying.
p.m. the matter can be shifted to the next
No.
week.
My 2 p.m. I'll bring back the learned friend, my lord.
Yes.
My lord, we mentioned before, your lordship, my lord, that already my lord, payment has been made, but the matter is fixed on 27 January. But
Yes.
instead of 27 January, it can be, if it can be taken on the next week, my lord.
27th, you please
My
mention.
lord, 27,
Not
I'll be not there, my lord.
somebody here.
It's a
Let your
serious
other
problem.
side. Let your other side mention before the court.
Yes, well, I'll try to bring him, my lord.
Not today. On 27th, when the matter will appear in the list, then please.
Well,
So
already-
somebody, if your other side also mentions, then also it can be adjourned.
Well-
But today, nothing can be done. Yes.
Yeah, my lords, kindly to mention a matter I'm mentioning upon notice. This is for extension of interim or of a matter.
When is it expiring?
On the 31st of January from the list in termination of Honorable Durag.
We will give.
Extremely much.
No, sorry.
May I please be permitted to mention two writs of similar nature, my lord, for upgradation.
No, sorry, no upgradations.
May we allowed to mention one matter, also item number 69 of today's Lease, Lordship. The
Upgradation?
urgency, Your Lordship, kindly Lordship, fix this matter, take this matter up on Monday or any day, Lordship,
All
because
right.
some urgency is there, Your Lordship.
Let's see. Call the
Kindly, Lordship,
witness.
since Your Lordship, the endorsement of the firearm, Your Lordship, that is, Your Lordship, been revoked by the district magistrate, Your Lordship. Now, Your Lordship, urgency is that the petitioner is the, Your Lordship, professional shooter. And now, Your Lordship, that if the firearm license will not be, Your Lordship, granted to in favor of that particular person, Your Lordship, he will not be allowed to, Your Lordship, participate in the sports, Your Lordship.
Your Lordship.
That is the urgency, Your Lordship.
Your Lordship, in this matter, I'm appearing for the petitioner. I'm being led by Mr. Anuj Singh. He's not available today. I'm just praying for not today. And on the same self cause of action, an appeal is pending in courtroom number 1, which will be heard today. So if this matter can be kept on any other day, Your Lordship.
Lordship, I am for the respondent. I am filing one supplementary affidavit, Your Lordship.
Respondent filing supplementary. Supplementary to what? Has opposition been filed?
Lordship, it has been filed.
Has the supplementary been
No, I am serving it right now, Lordship.
What is it? What is there in the supplementary?
Your Lordship, there are some new facts, Your Lordship.
Facts. But the writ petition will be decided upon the facts which are already there in the writ petition.
No, Your Lordship, they have filed one similar writ petition against SBI, where Your Lordship, Honorable Justice Sabyasachi Bhattacharya has passed the order. Lordship, on the last occasion, they have contended that this matter should be passed on the basis of that order. But there are few facts, Your Lordship, we differentiate this matter from that matter. These are the
An
facts.
appeal has been carried from the order of Justice Bhattacharya?
Yes.
That I am not aware, Lordship.
Learned advocate representing the petitioners seeks accommodation. Stop. It has been submitted that an appeal has been carried from an order passed in a similar matter. Stop. The appeal is likely to be taken up for consideration shortly. Stop. Next. Supplementary affidavit has been filed on behalf of the respondents. Stop. The same is taken on record. Stop. Let copy of the same be served upon the learned advocate representing the petitioners.
Lordship, I have served the copy, Your Lordship.
When?
Now, Your Lordship.
Acha.
Yes, Your Lordship.
Served likhun. Copy of the same has been served upon the learned advocate for the petitioners in court today. Acha. Let the matter appear in the list on 17th of February.
Obliged, Your
Grateful, Lordship.
My lord, I am for the petitioner being led by Kushal Chatterjee. Due to his personal reasons, he is not available. He has not come to court today. Kindly fix it on Tuesday or Wednesday next week.
I appeal for the respondent number 2, my lord.
He's taken his father to doctor. That's why I'm praying.
Application for modification.
My lord, that has been allowed by your lordship on the last
Alright.
occasion, but the application has been kept, my lord, along with the record because one of the annexure annexed to that application.
Oh, the list of employees who expired while in service. All right.
The only issue was, my lord, they are relying on a document, my lord, which according to us, my lord, was my lord, modified.
Provide the details of the employees who retired from service. Some benefits have been withdrawn.
No, my lord, their allegation.
Whatever it is, an accommodation has been sought for by the learned counsel representing the petitioner. Stop. List on 17th February.
Good. Company.
My lord, in this matter, I'm led by Mr. Chakraborty. He's on his legs. My lord, before he comes, my lord, I can start, my lord.
Yes, who's stopping you?
My lord. My lord, my writ petition.
Bank Lordship, respondents.
My lord, my writ petition, where I have challenged, my lord, the declaration and classification by the bank of my accounts, my lord, as a fraud account. My lord, here, my lord, what has happened? My lord, the willful defaulters identification committee, my lord, has given a decision on, my lord, 22nd of February 2019 in respect of a show cause notice of 2016. My lord, the bank's contention is, my lord, that the account was classified as NPA, my lord, sometime on 31st December 2015. My lord, thereafter, the show cause notice was issued, my lord, which we have replied to. And bank has also sent a response to our reply. After that, my lord, 3 years, nothing has been done by the bank. My lord, suddenly, my lord, the bank has, my lord, issued a decision by the identification committee in 2019. My lord, and thereafter, my lord, the review committee confirmed that, my lord, identification committee's decision. That happened in 2021. Now, my lord, I stand corrected, my lord, that also happened in 2019. Meantime, my lord, what has happened? My lord, I have, my lord, 5 companies. My lord, out of the 5 companies, 1 company has been dissolved. My lord, the company was at first, my lord, under the Insolvency and Bankruptcy Code. My lord, the company was sent into, my lord, corporate insolvency resolution process, which, my lord, culminated into liquidation in the year, my lord, 2019. And, my lord, subsequently, this company has been dissolved. So, my lord, this is the first company. My lord, the second company, in respect of which, my lord, notices has been issued, my lord, that is also sent into liquidation.
What is your prayer?
My lord, my prayer is, my lord, declaration so far as the, my lord, petitioners who were the directors of these companies, my lord, their account has been declared as fraud account.
Yes.
That declaration of fraud is, my lord, what I am challenging before, my lord. Because, my lord, the status of the companies which are there, my lord, 2 companies, 1 dissolved, 1 company liquidation, and, my lord, the bank has lodged their claim, my lord, in respect of both these companies with the, my lord, the liquidator appointed by the tribunal under the code. Now, my lord, the 3 companies which are there are 5 companies, my lord. My lord, the 3 companies, my lord, which are there, my lord, there has been an order of admission, my lord, for insolvency resolution by the learned NCLT tribunal. My lord, that was in the year 2023. After that, my lord, that has been challenged by us before the appellate tribunal. Appellate tribunal, my lord, passed an order of stay, my lord, with regard to, my lord, committee of creditors not taking any decision with regard to the, my lord, insolvency of the company. In the meantime, what has happened, my lord, and the bank has also filed a supplementary affidavit before my lord, the bank has assigned the loan. My lord, that assignment was to a, my lord, ARC company. My lord, that has happened, my lord, in November, December 2024. My lord, after assignment, my lord, the bank has disclosed, my lord, the assignment documents, my lord, in their supplementary affidavit. And my lord, they have stated, if my lord kindly takes their supplementary affidavit once. Supplementary affidavit. My lord, this is affirmed, my lord, sometime in January 2025.
I had appraised the subsequent facts. Lordship had given me leave, I had filed this affidavit.
Yes.
My lord, kindly sees, my lord, paragraph 2 of this affidavit, my lord, if I may place, that the respondent number 1 has assigned the loan disbursed to the principal borrower under financing documents together with its right, title and interest in the financing documents and underlying security interest pledges and guarantees in respect of such loans extended to the borrower by the applicant as envisaged under section 5(1)(b) of the SURFACI Act to ASREC India Limited. Now, my lord, kindly sees, my lord, they have annexed the, my lord, assignment agreement, 28 November 2024. Now, my lord, kindly takes paragraph 3. My lord, this is also very important, that on 6th August 2018, an application being IA number 719 of 2018 relating to fraudulent transaction was filed by Sumit Binani, the liquidator appointed in CPIB number such and such at NCLT Kolkata against the suspended members of the board of directors of the corporate debtor, namely the writ petitioners, to refund the sum of rupees 24 crore and odd which has allegedly been siphoned off through related parties, that subsequently the liquidation process as regards to the corporate debtor RG Shaw, this is one of the companies which is now dissolved, has ended, that the application being 719 of 2018 filed by the liquidator relating to fraudulent transaction is still pending consideration. The bank, the sole member of the COC, which is the Committee of Creditors, has agreed to pursue IA number 719 of 2018. State Bank of India, the sole COC member, has agreed to pursue IA number 719 of 2018 and bear the cost thereof. Pursuant to order dated 15 July 2024, the application being IA number 1388 filed by the State Bank of India was allowed by the Honorable NCLT Kolkata bench, permitting State Bank to enter appearance through counsel and to get substituted in place of the liquidator in the application being IA number 719 of 2018. So, my lord, now they are proceeding with, my lord, the fraudulent transaction application against the, my lord, suspended board of RG Shaw, that company which is now dissolved. My lord,
But madam, your application is pending before the tribunal.
Absolutely.
Why will the court, this writ court enter into all these things?
I'm led by my
Yes.
My lord, my grievance is not pendency of a proceedings. My lord, in a certiorari, I cannot come before a writ court asking for supervisory jurisdiction. I can. My grievance is my lord, volume 2. My lord, 154. এই জায়গাটা উত্তর আছে, এই জায়গাটা আছে।
Yes.
My lord, would kindly see brief details of the stressed loan exposures, show cause, so and so. Below, my lord, after the table, the above units have been declared as fraud. My lord, this is my grievance. Before any adjudication, you have already declared this as a fraud. Then why did you file your application, which is pending from 2018? And before any decision of the NCLT, they have already declared this as a fraud. My lord, now this fraud under the RBI guidelines, there is a specific notifications. My lord, I'm just 2 or 3 dates. 2016, a show cause notice was issued to me saying that I am.
Show me the guidelines which you are relying upon.
Yes, ma'am. The guidelines to the Hard copy. কোথায় নেই তো? না, ওটা willful default. ওটা willful default, এটা আমারটা তো mine is marked. That's a difficulty, my lord. Can I solve?
No, you show the hard copy, no difficulty.
Is marked, my lord. This
Doesn't
is
matter.
kindly see penal measures for fraudulent. My contention is,
Hmm.
my lord, may I just give two dates
Hmm.
before my lord sees this. 2016, I was given a show for willful default, not for fraudulent account. 2019, I was declared as the willful default, and that penal measures is for 5 years. 5 years only, my lord. At the age, my lord, now in 2024, when I first time come to know, after the period of 5 years, they now declare this to be a fraudulent account without any show cause, without any prior notice, without any hearing. My lord, the judgment which I was relying upon, that was also in the month of March 2023, and this order, particular web checking, is dated November 23. So that is also, my lord, would find 17 November 2023, and the judgment, my lord, a copy was handed over, my lord. That is also delivered in the March 2023. My lord, that is my grievance. My lord, pendency of matter before a bench, I have a requisite remedy. But the question is, before the result or before the outcome of that proceedings, this accounts can be declared as fraudulent or not? This is my simple grievance. Malad, the Supreme Court says, Malad, I'll show the difference, the measures, the penal measures taken under this provision is completely different from the penal measures taken under the willful default. Here, my lord would find willful, the word is 5 years till from the date I pay the money.
Yes, 5 years from the date of full payment of the
Full payment. And
account.
now kindly see, my lord, my here under the willful default, what is the consequences, which is at page 146. 146 of the second volume. Kindly see, my lord. A.
Yes.
No as additional facilities should be granted by any bank. My lord, 2.5A. No additional facilities should be granted by any bank, financial institution to be listed willful defaulters. In addition, the entrepreneurs, promoters of the companies where banks, financial institutions have identified siphoning, diversion of funds, misrepresentation, falsification of accounts, and fraudulent transactions should be debarred from institutional finance, from the scheduled commercial bank, so and so, investment institution, etc., for floating new ventures for a period of 5 years from the date of name of the willful defaulter is published in the list of willful defaulters by the RBI. So, my lord, 2019 I was declared. So 2000 till this clause, penal clause continues 2024. Now in 2024, again they say these accounts are fraudulent transactions. But for the same transaction, I cannot be prosecuted twice. But that is that's a principle of double jeopardy on the same allegations. And now you say, Malad, I can show the show cause notice. They never use the word fraud. They never use the word fraud.
In the guidelines, is
Yes.
there anything mentioned as to how an account is to be identified as
Yes,
fraud?
Malad, kindly.
Sure.
And Malad, entire process is exhaustive. Malad, may I come back to the judgment whether the rules have been incorporated? That would be better.
Did you hand over a copy?
Yes, Malad.
Rajesh Agarwal?
Yes. এটা ফুল ফর্মটা মনে আছে না? RFA টা RFA ক্লজে আছে প্রথম দিকে। My lord, kindly starts from the paragraph 17.
70
17.
17. Yes.
Matlab, this is where the power, and 20 is the master circular which I had which I had handed over. Paragraph 20.
Mm.
Those directions are issued with a view to providing framework to banks to enable them to direct and report frauds early. My lord, this purpose directions are issued with a view to providing a framework to banks to enable them to detect and report frauds early and taking timely consequent actions like reporting to the investigative agency so that fraudsters are brought to book early, examining staff accountability and do effective fraud risk management. So matlab, early, matlab, 2016 these transactions we are to speaking of. These directions are also aimed to enable faster dissemination of information by the Reserve Bank of India to banks on the details of frauds, unscrupulous borrowers, and related parties based on the bank's reporting so that necessary safeguards, preventive measures by way of appropriate procedure, and internal checks may be introduced and caution exercised while dealing with such parties by the bank. Now it quotes, now kindly see paragraph 23. Clause 3 advises banks to make full use of central fraud registry, a database, so and so, for timely identification, control, reporting, and mitigation of risk associated with fraud. Clause 3.3 of the said direction emphasizes the need to provide timely information on frauds and penalizes banks for non-adherence to the timelines. So, banks are also prosecuted under these rules if they do not follow the timeline. My lord, now kindly see this. They have recorded, my lord, the relevant. My lord had asked me paragraph 34. The penal measures for fraudulent borrowers are set out in clause 8.2.12.1, which I had shown. Now, my lord, vis-a-vis 35. What is the difference? Clause 8.12.1 provides that the penal provisions as applicable to willful defaulter will apply to fraudulent borrowers as regards the raising of funds from the banking system and financial institution. Importantly, under the clause, fraudulent borrowers include promoters, directors, and other whole-time directors of the borrowing company. It debars fraudulent borrower from availing bank finance from the scheduled commercial bank, development, financial institution, government, NBFC, investment institution, etc., for a period of 5 years from the date of the full payment of the defrauded amount. Even after the completion of the 5 years, it is for the individual financial institution to decide whether to lend fraudulent borrowers, including directors and promoters of the borrowing company. Additionally, under clause 8.12.2, fraudulent borrowers are denied restructuring or grant of additional facilities by bank, such as financial institution. But pausing here for a moment, it is something that I carry forward for the rest of my life. That's a difference between a willful declaration under a willful defaulter, under a willful declaration, and a fraudulent declaration. It is more harsh, more stringent, and that's why it requires, Supreme Court says, it requires pre-decisional hearing. Now, my lord would kindly see paragraph 40. The process of forming an informed opinion under the master direction on frauds is administrative in nature. This has also been acceded to by RBI and lender banks in their written submission. It is now a settled principle of law that the rule of odi alterum partem applies to administrative action apart from judicial and quasi-judicial function. It is also a settled position in administrative law that it is mandatory to provide for an opportunity of being heard when an administrative action results in civil consequences to a person or entity. Now, my lord, the difference has also been considered by Supreme Court willful. My lord, paragraph 52. The question in so and so was whether a person who is declared to be a willful defaulter according to the procedure laid down in the master circular or willful defaulter is entitled to be represented by a lawyer of their choice before such a decision is made. The court held that a borrower does not have the right to be represented by a lawyer in the course of in-house proceeding envisaged in para 3 of the master circular on willful defaulters. Para 3 of the master circular on willful defaulters provides a two-tier process for identification of a willful defaulter. At the first stage, a first committee headed by an executive director or equivalent and consisting of two other senior officers of the bank must, after examining the evidence of willful default and concluding that willful default has occurred, issue a show cause notice to the borrowers and the promoters, whole-time directors concerned calling for their submission. The first committee has to consider the submission before the recording the fact of willful default with reasons. If the committee deems it is necessary, it would also provide a personal hearing to the borrower and the promoter, whole-time director of the borrowing company. The second stage is that the order of the first committee is reviewed by another committee known as the review committee. Thus, it is clear that the procedure for declaration of a borrower as a willful defaulter is different from the procedure envisaged under the master direction on fraud for classifying the borrower's account as fraud. However, by virtue of clause 8.12.1 of the master direction on frauds, the penal provision applicable to willful defaulters also applies to fraudulent borrowers. Thus, although the procedure adopted for declaration of a willful default is different from that of an envisaged for classifying the borrower's account as fraud, they will face similar consequences. In fact, as mentioned above, the borrower's account classified as fraud under the master directions on fraud will face certain additional consequences which have been laid down in clause so and so, which I have already. Now, my lord, kindly see how masters of fraud to be declared. That is paragraph 55. Classification of borrower's account as fraud under the master direction on frauds virtually leads to credit freeze for the borrower who is debarred from raising funds from financial markets and capital markets. The bar from raising finances could be fatal for the borrowers, leading to civil death, in addition to the infraction of their rights under Article 19(1)(g) of the Constitution. Since debarring disentitles a person or entities from exercising rights or privilege, it is elementary that the principles of natural justice should be made applicable, and the person against whom an action of debarment is sought should be given an opportunity of being heard.
So your case is that prior to your declaration of fraud, no opportunity of hearing was given to you.
No notice, my lord. No notice. The first time I come to know from the website that this notice has been uploaded. Nothing, my lord, nothing has been given. And my lord, the consequences are much more stringent. My lord, kindly appreciate. 2016, the transaction started, the proceedings. Everything comes to an end in 2024. Again, they starts it for fraud.
Yes.
Lordship, actually, in the writ petition, he has mostly challenged the review committee order and the willful default committee order. So, regarding fraud, Lordship kindly allows me 1 day to take some
There is
instruction.
no submission with regard to fraud in the entire writ petition.
No, they actually regarding fraud, Lordship, only in the mandamus last line, I'm seeing that regarding web notice. And
is any case made out that prior to putting up his name as a fraud,
Lordship, mostly the grounds are dealing with the identification committee order and the review committee order, that I have not been given a chance to represent myself. So regarding fraud, Lordship kindly allows me 1 day, Lordship.
And this is your only case?
Regarding fraud.
Yes, my lord, that as willful default, my lord, with
It's
deepest,
different.
it is already over, my lord. 5 years I have already passed
So he's
that.
no longer challenging in the mandamus portion, also he's
willful default
he's
goes. He
giving it a pass, yes. Regarding
he accepts.
yes. So regarding fraud, lordship kindly allows me 1 day time to take instruction.
They have used an affidavit, my lord.
No, I have not
No,
used an
you-
affidavit.
well, that
Only
is-
subsequent events I have given.
Well, that is what they have said in the
Regarding-
affidavit.
There is
No, no,
nothing in the affidavit.
The proof of
They-
application for
only
the NCLT is
opportunity
pending.
of
That is what
hearing
I've said.
was whether opportunity of hearing was given or not. Nothing
Well,
more than
that is what
Yes.
my lord had inquired. Kindly see the previous order. For that reason, my lord had asked them to file the affidavit. Kindly see.
It was only for the assignment reason. I said that I want to place
kindly-
the assignment
my lord, 19
document on
December,
record.
my lord, please. 19 December, kindly see. The petitioners are aggrieved by the manner in which steps were taken by the State Bank in declaring the subject bank account as fraud. Learned seeks time to revert with instruction.
Yes, yes.
My lord, now my learned friend is saying that he has not used an affidavit for this purpose.
But
How incorrect you can be?
But my submission was only for
Madam,
the
how-
assignment, lordship.
Or submission of the petitioner is that? He has been declared
Okay, sir.
as fraud without affording a prior opportunity of hearing. Stop. Next. Learned advocate representing the respondents seeks time
Paragraph
to take
22 I have
instruction
mentioned
as
specifically
to
without any
whether
notice. Also.
any opportunity of hearing was given to the petitioners prior to declaration of fraud. Right? How soon?
Lordship gives me 1 day, lordship. You can take up on Monday or Tuesday.
Tuesday, 28th.
Grateful, my lord.
I'm grateful, my lord.
Deeply obliged, my lord.
No, please, RBI guideline. Please, please, please. Madam, may I take back the guideline, my lord? Sorry, my lord, I had
it back.
handed over the marked copy.
আর কি original set এও কিছু আছে? কি নিচ্ছেন?
My lord is taking the appellate side. My lord, may I be permitted to mention one matter, my lord? For
But
upgradation.
mentioning is over.
No, in the morning, I knew, my lord, but may I come back on Monday, my lord?
I appeal for the petitioner, my lord. My lord, the petitioner is not willing to proceed with the case, my lord. It has actually virtually become infractious.
Why?
That
আর একটা মাঠের আসার কথা ছিল।
the tender matter, my lord, the L1 bidder, L1 and N2 bidder bids were challenged. But the tender has virtually come to an end. My lord, period has expired. Is going to expire.
Please come. Learned advocate representing the petitioners submits upon instruction that the writ petition has become practically infructuous due to efflux of time. Stop. In view of the aforesaid submission, the writ petition stands dismissed as infructuous.
Grateful.
You are for?
I'm for the LIC, respondent number 225.
Respondent number 225. Please put in your appearance.
Yes.
Grateful, my lord.
Grateful.
My lord, I appear for the petitioner, my lord. This has come at my instance, my lord, for non-prosecution, my lord, with liberty to file afresh.
Right.
My lord, the difficulty is, my lord, there are defects in the writ petition. One of such, if your lordship says, I may point out, my lord, in the prayer portion, the
No,
date.
you say there are defects.
There are defects, my lord. With liberty to file afresh, my lord, other written instructions we kept on record.
Dismissed because of defects. Liberty to file afresh. একটা order আমাদের already আছে. Yes.
My lord, the written instructions may be.
Respondent appearance. The instruction দিচ্ছে রেখে দিন।
Your lordship has been pleased to grant liberty, my lord. Deeply obliged, my lord.
Your Lordship, I'm appearing for the petitioner in this matter. There was a order restraining the bank from taking any coercive step till today. Mr. Shuddhoshatto Banerjee is appearing in the matter. He has not been able to reach court till now. I was humbly praying if this could be extended and the matter could be kept on Monday. If Your Lordship so pleases.
I have an objection with regard to extension of the hearing permit because the document on which they relied upon or on which my lord was used to run the hearing, it's not at all relevant, not only relevant, it is quite misleading also. That I would satisfy my.
Did you get the necessary records? It's there with you? Hold it back. Hold it back. Don't return it till it is heard. The interim order that is subsisting in the matter is extended till 31st of January 2025 or until further orders 28th, Tuesday.
Your Lordship has been pleased to keep it on 28th of February.
Yes.
28th of January. Grateful, Your Lordship.
January. তো 31 জানুয়ারি পর্যন্ত এক্সটেনশন।
That contempt application is of 2004.
That is wrong.
Yes.
Wrong file has come.
Yes,
The
but
proper
it is
file has to come.
a contempt application is already in the file as told by the court officer, Your Lordship.
Contempt ফাইলটা কি আছে? আছে? Yes.
Your Lordship, in annexure A2, page 17, Your Lordship.
We have preferred an appeal against the order dated 20th December. Pending Your Lordship.
Your Lordship. No, Your Lordship. No. They always file some of the other appeal, Your Lordship. This is a contempt application against the Bar Council. And as per the direction of Honorable Court dated 2012-24, virtual link was to be given to me and my junior, Your Lordship. I prayed for the virtual link on the same day. I was not provided. That is in
Show me
page
the document.
19, page 19, Your Lordship. Annexure A2. Kindly share the link for virtual hearing in the disciplinary proceeding of 24 of 2024. Contempt application, Your Lordship. Yes. চারটে কপি পাঠানো হয়েছে আপনাদের। Now, Your Lordship, they did not provide me the link. I had prayed for a time of
1 minute, page 19.
Page 19. On the same day, I had prayed for the virtual link.
Yes.
Since the proceeding was scheduled on the same day at 4 p.m.
Yes.
I sent the mail at 1:32. I did not receive any reply. At 4 p.m., for 1 minute past 4, I sent another mail that time may be granted to file objection for 3 weeks, Your Lordship. I was not replied, and I repeatedly requested them to send the copy of the order of 20th 12. Now, Your Lordship, the copies of the objections were duly served, and they received the copy of my objection, but order was not sent. till 16th of this month. Your Lordship may kindly see.
Wait 1 minute.
Yes.
20th of December.
And as per the order of 26th November, Your Lordship, I was not directed to file the objection in the meantime. I was directed to file objection on 20th 12 at 4 p.m.
Show the earlier order.
Yes, Your Lordship, at page 28. Page 28. Last few lines of the first paragraph on 20/12/24 at 4 p.m. for filing affidavit of service by the complainant and for filing objection, if any, by the opposite party in connection with the application under 6 Rule 17. And in the order of 2012, Your Lordship, which is at page 25, it is written that the opposite party was directed.
Yes, I've seen that.
That in the meantime, I was to file the objection.
All right. Yes. Why was the link not provided?
I not have to take instruction in this respect.
Today there is another hearing. Today there is a hearing.
No, it's on 29th, Your Lordship, and my junior has also been served with the similar order that if she doesn't appear on 5th of February, it will be
not.
It will.
I am hearing a contempt petition. You are no longer here. Do not make any submission. You are appearing in person.
No.
You are the advocate. Very well, please wait. The court is not asked you to appear. This is a contempt matter and the court is not concerned with your appearance. You are not a party. So don't make submission.
Your Lordship, the
1 minute.
Yes.
The matter is fixed before the Bar Council on 29th. Please take instruction as to why the link was not provided despite order being passed by the court and despite communication of the order.
Yes.
Please come.
My
And they have also
my
mentioned
contempt appearance is wrongly appearing, my that is
Yes,
that is
yes, by mistake.
Yes, yes.
You are not required.
No,
Acha.
hearing.
The contempt application has been filed.
And
by the petitioners alleging non-compliance of the direction passed by this court on 20th of December 2024. Stop. Paragraph, despite specific direction being passed upon the Bar Council. No, apni likhun. Direction was passed upon the Bar Council to permit the petitioners to defend themselves in the disciplinary proceedings through the virtual mode as the Bar Council permits virtual hearings. কি বললাম? But in complete violation of the said direction, the virtual link was not provided to the petitioners. Stop. Learned advocate representing the Bar Council seeks time to take instruction. Stop. List the matter on 28th. Atash.
Your Lordship, despite submitting the written objection that has been
let her take instruction.
Obliged, Your Lordship. Affidavit of service. Affidavit of
আচ্ছা
service.
সুব্রত বাবু একটা অর্ডার লিখ by mistake Stop. Let
It's
the
a very
scene be.
peculiar situation in which I think everybody's intervention is called for. But the petitioner is an Indian citizen. He had married a Russian citizen, a woman. Now, fight between the parents are going on as usual, so far the custody is concerned. And kindly turn to page 55, the Honorable Supreme Court had passed an order. So, for the right of visitation of the mother is concerned, this is important. It starts from page 49. Relevant portion is at page 55.
49 একটা order.
Nah, 55 relevant order.
55
On oral mention.
What is the proceeding before the Supreme Court?
This is without proceedings. I mean, the habeas corpus petition.
Habeas corpus. All right, habeas corpus by the mother. Seeking the custody of the child. All right. Then
we are informed that a violent incident between the parties took place today in the morning, which is being inquired and investigated by the Barakhambarat police station. However, the manner in which the petitioner responded to are alleged to have quarreled calls for immediate modification of our order in the following terms. The petitioner undertakes to shift to a PG accommodation taken by her on rent in Defence Colony. Respondent number 2 also undertake to shift to a private accommodation near Defence Colony within 1 week. While the parties will stay separately, the child shall remain in their joint custody. The child shall remain in exclusive custody of the petitioner wife from 4 p.m. to 8 p.m. Thereafter, the respondent number 2 shall take the child to stay with him, and in the night also the child shall continue to stay with him. Therefore, the right of visitation to the mother was for few hours, 4 p.m. to 8 p.m. Now, the petitioner has not had a passport, an Indian-born child, Indian passport. Now, the lady who is a Russian citizen very surreptitiously obtained a passport from Russia for showing her kid and claiming to be the mother in custody. In that view of the matter, the department has issued a notice at page 97, which is under challenge before this court. You may recall
what happened to the proceeding before the Supreme Court?
Still pending about the right of visitation and custody.
So this is page 55 is the last order that
last order which is not valid as on today.
No, page 49 একটা order আছে,
last order to contact.
Page 49.
Page 49.
Page,
Not 55.
Not page 49.
Page 49. Kindly turn to page 49.
49 say.
Yes, let us note page the 49 also.
Mediation Center.
49 is the Supreme Court Mediation Center has sent an interim mediation report dated so and so. According to the said report, there is every possibility of settlement of the matrimonial dispute on the joint request made by learned counsel for the parties post on the matter under further heading on so and so. Nothing has happened. The earlier order of visitation is the valid order. Now the mother, unfortunately, being a Russian citizen, wants to shift an Indian-born citizen who is a kid now, obtaining a passport surreptitiously from Russia.
What is the age of the son?
4 years.
4 years.
4 years. All right.
Now, the passport authority, maybe by taking the ordinary course of procedure, wanted to revoke the passport which he had obtained as I say, repeat Indian-born citizen, matter of right. He is India. Kindly come to page 97. That is the impugned now. You may recall that on the basis of the passport application number such and such of your minor son, an Indian passport bearing number with validity from 11th of March 2021 to 10th of March 26 was issued to him. Kindly note the date. 11th March 2021 is a prior point of time, and the Russian passport is subsequent thereto. Of late, it has come to the knowledge of this office from ministry that your minor son has obtained. First of all, minor son cannot obtain a passport. Russian passport bearing number such and such on 15 January 2024. So obviously, Russian passport is a subsequent one. And that too, the minor being an Indian born, his citizenship is going to be ultimately affected if this recall notice is sustained. But this is not a matter on which we want to fight. I would request personally, as a counsel to Mr. Additional Solicitor General, to ask his department to take the rational view. How could an Indian-born citizen be
And what does this line mean? Consequent upon acquisition
Yes,
of Russian
because it's
nationality?
subsequent passport by Russian mother has obtained it.
Yes. and
Therefore,
that
your
is-
earlier passport should be recalled.
And you become a Russian national.
That's ultimately that's so. No, no, I'm an Indian, there's no dispute to that. And particularly when the custody, technically joint custody, but the right of visitation is only for 4 hours. My lord. No, no, boy, not like that.
Passport.
Passport Act.
Passport Act is there. Let's go now. Hmm?
Passport Act.
Yes, Ms. Over.
আমাদের বই ছিল কোথায় গেল? Passport Act দেখবেন তো।
10.3.8.
Yes.
But kindly turn to the section 10.3. Variation, impounding, and revocation of passports and travel documents. The passport authority may, having regard to the provisions of so and so, so and so, of section 6 or notification under section 19, vary or cancel the endorsements of the passport to travel document with the previous approval of the central government. Vary or cancel, this is not in 3. The passport authority may impound or cause to be impounded or revoke a passport or travel document if the passport authority is satisfied that the holder of the passport or travel document is in wrongful possession thereof. If the passport to travel document was obtained by the suppression of material for information.
That is not relevant.
Nothing is
It
applicable.
3A.
3 is also not
That
applicable.
means you are holding wrongful possession. Very well.
No, how could the minor be said? I think then this requires not the appropriate intervention. Bolo.
Did you reply? 26
Yes, we have given it.
days.
For
98.
Reply it.
Page 9.
Why it is your notice that is under challenge.
Law is well set. Once a passport has been granted to the minor son by the Russian government, she automatically loses citizenship under section 8 and 9 of the Citizenship Act. It is well settled. Secondly, he cannot maintain the passport at all acquisition of citizenship of a Russian. Now, I'm placing first section 8 and 9 of the Citizenship Act.
No, but see, child is a minor.
Yes.
Right? He independently cannot do anything. Relationship between the parents of the child is clear before you from the documents that are annexed. A matrimonial proceeding is pending consideration before the Supreme Court. Mediation is going on. 28th is the date fixed. In the meantime, the officer taking such a view appears to be not proper.
The view which has been taken is clearly in terms of the passport.
No.
Maybe. Maybe.
Secondly, your Lordship will kindly consider that nothing has been decided by us, and the petitioner has submitted before the jurisdiction by filing a reply to the show cause.
Yes.
So how does the reply now?
Very well. You decide the show cause reply, and till such time decision is taken and order is passed by the Supreme Court. No.
Supreme Court is not adjudicating the passport issue.
Not adjudicating, but the custody of the child is in. Custody is there.
Of the minor cancelled. He attending the majority will get back the citizenship.
No.
It is, he is now 4 years. He is 4 years. Attaining majority will be 18 years.
I am asking a very simple question. Whether in view of acquisition of Afghan citizenship, there is no provision in the Citizenship Act. The passport is automatically cancelled.
No. Right.
Now it has to be decided whether the child who doesn't have an independent consent, whether he can obtain a citizenship of some other country. This is the issue.
Decided by the passport authority because they have submitted before us.
Very well. Let the passport authority decide, but don't take any coercive steps. Please come.
দরকার নেই তো ওরা বুঝতেই পারবে না সেকশন 8
The
application note
petitioner
আছে,
is
ওরা
the
রোল
father
submission
of a
section 8 হচ্ছে
4-year-old
informed person child
male child.
পড়ো পড়ো তুমি না দেখে বলেছো পরে তুমি এক্সেপ্ট করবো ঝগড়া
Stop.
করবো না
The
if any citizen of
the
India of
um,
full age and
the
capacity of
relationship between the parent, no, the relationship between the petitioner and his wife is acrimonious. Stop. The petitioner is an Indian citizen, but his wife is a citizen of Russia. Stop. An issue with regard to the custody of the minor's son is pending consideration before the Honorable Supreme Court. Stop. The Honorable Supreme Court was pleased to direct the parties to the mediation center for resolution of the matrimonial dispute. Stop. The Supreme Court took note of the interim mediation report dated 11th of November 2024, filed by the Supreme Court Mediation Center, that there is every possibility of settlement of the matrimonial dispute. The matter has been made returnable on 28th of January 2025.
কে চ্যালেঞ্জ করবে
Paragraph. In the meantime, the passport of the minor son of the petitioner, which was passport the Indian passport, which was valid from 11th March 2021 to 10th March 2026, has been sought to be cancelled by the Deputy Passport Officer on account of consequent acquisition of the Russian nationality and passport by the minor son on 15th of January 2024. Stop. The petitioner has been asked to show cause as to why the Indian passport issued in favor of his minor son should not be revoked under section 10 within bracket 3 within bracket small a of the Passports Act 1967. Stop. The petitioner has been given 21 days to submit the reply to the show cause. Stop. The petitioner has duly submitted the reply on 15th of December 2024. Stop. The authority is yet to take a decision in the matter. Stop. The petitioner is apprehensive that if the authority cancels the, not cancels, revokes the Indian passport, then it may not be possible for the petitioner to keep the child in his custody. Stop. Paragraph.
and also suffer his citizenship.
The petitioner in custody and his child may lose the Indian citizenship. Acha. From the order passed by the Honorable Supreme Court on 13th of July 2023, it appears that the Supreme Court in the writ petition within bracket criminal number 129/2023 was pleased to direct that the child shall remain in exclusive custody of the mother from 4 p.m. to 8 p.m. and the father shall take the child with him in the night,
20 hours.
and the child shall continue to stay with him. Stop. Paragraph. The said order is valid till date. Stop. If the passport authority opines of revoking the Indian passport of the minor son of the petitioner, comma, then the order passed by the Honorable Supreme Court will be rendered unworkable. Stop. Paragraph. The learned Additional Solicitor General of India submits that the authority took steps strictly in accordance with the provisions of law. Stop. Next. Paragraph. It has been contended that as the petitioner has submitted to the jurisdiction of the passport officer, accordingly, the writ petition is liable not to be entertained. Paragraph. I have heard the submission made on behalf of the parties. Stop. The petitioner appears to have replied to the show cause notice. Stop. The deputy passport officer is yet to take a decision in the matter. Stop. Paragraph. The deputy passport officer is directed to deal with the reply filed by the petitioner. Keeping in view, in accordance with the provisions of law and keeping in view the pending order passed by the Honorable Supreme Court in the writ petition filed by the wife of the petitioner herein. Stop. The passport officer shall keep in mind that the issue of custody is still pending consideration before the Honorable Supreme Court, and passing any order in connection with the passport of the minor son, minor child may may stand as an impediment in proper adjudication of the list that is pending before the Supreme Court. The writ petition stands disposed of.
No, kindly grant us some date for consideration and disposal of the proposed notice.
Take your time. The matter is pending before the Supreme Court. Acha,
My lord, will not kindly dispose the matter at this stage.
I will not dispose.
Now, kindly keep it pending. Let's see what the order they pass then.
I will give you leave to draw attention of the Supreme Court with this also. That will solve the problem.
And if an order is passed, it's a fresh objection. Why the writ petition will be kept pending?
Yes. Acha.
Supreme Court can take a decision of the entire matter.
The as the matter pending before the Honorable Supreme Court is due to appear before the list before the court for consideration on 28th of January 2025, liberty is granted to the petitioner to bring the instant fact to the notice of the Honorable Supreme Court.
Writ petition is disposed of. Well, allegations are denied. Since there is no.
What is the allegation against
No, we
you?
have not found any opposition.
I understand, but is there any allegation against you?
Yes.
ঠিক আছে. As the writ petition is being disposed of without calling for any affidavits, the allegations made therein are deemed not to have been admitted by the respondents.
Millard,
I appear on behalf of the respondent number 4.
Millard, a tender was floated, Millard, way back in 7th November 2017, Millard, in respect of long-term mining lease, Millard, Millard, sand blocks, Millard, of Paschim Bardhaman. Highest bidders, Millard, my client was, Millard, selected. Now, Millard, 18, Millard, 19th March 2018, lease was executed. Short facts, Millard. May 2019, Millard, sand block was handed over to the petitioner. 21st May 2019, certificate of possession was issued. 3rd July, order was passed by the authorities to stop mining activities for monsoon. 3rd July, monsoon started. 1912, Millard, after 5 months, lifting the aforesaid closure order. 20th December 2099, I started, Millard, extraction of sand on the riverbed. Then, Millard, 21st March to 35 May 2020, due to, Millard, the COVID, Millard, 19, Millard, I had to close all of my activities. Then, Millard, again, Millard, on 3rd July, order was passed to stop mining activities. 11 lifting, Millard, sorry. Then a restriction order was suddenly passed on 7th July 2021 in view of
what is the immediate cause of action?
immediate cause of action, Millard. My lease expired in 2024, 5 years. I could not, Millard, because of the consistent resistance, Millard, I could not, Millard, lift, Millard, the actual code that was allotted to, Millard, to me, resigned, Millard, to allotted to me. And ultimately, by reason of such delay, my lease expired. I made a representation for extension. Now, Millard, in a similar, there was a force majeure clause, Millard, and certain situation, Millard, I was only allowed to do mining activities only 553 days. And Millard, I was not able, Millard, to Millard, lift, Millard, the actual amount of sand, Millard, which I am entitled to under the contract. Lease document says, page 75, Millard, that the force majeure clause. Now, Millard, in a similar facts and circumstances, Millard, your lordship's court, Millard, 75, Millard, clause 5, failure on the part of the lessees to fulfill any of the terms, conditions of the lease shall not give the state government any claim against the lessee or lessees or be deemed a breach of this lease, insofar as such failure is considered by the state government to arise from the force majeure. And if through force majeure the fulfillment by lessee of the terms and conditions of this lease be delayed, the period of such delay shall be added to the period fixed by this lease. In this clause, expression force majeure means act of God, war, insurrection, riot, civil commotion, strike, earthquake, tide, storm, tidal wave, flood, lightning, explosion, fire, and other happenings.
Has your prayer for renewal been
Not
rejected?
considered.
Not considered.
Not considered, and I am, Millard, supported by a judgment of your lordship's court as single bench.
Please show your application seeking renewal.
My representation, Millard, at 19, Millard, 119. Election 19, Millard. Page 114. Right? Millard, I enumerated all my difficulties, Millard, and Millard, I request your lordship, Millard, with humility.
And your last date of the contract? Validity period?
18th of March 2024.
24. Why are you coming now?
The petition is pending, Millard, for not, Millard, for when they are issuing a tender. I came before your lord. In this writ petition, I have mentioned
From
one
March
writ petition.
24 till the filing of the writ petition on the 13th of January 2025, did you
Millard, I filed a writ petition alleging the inaction on the part of the respondent for not considering this claim after the expiry of the lease. This writ petition, paragraph 27, Millard, kindly takes page 13.
What have you stated?
This is pending.
But did you
For
lift,
your lordship.
Did you lift?
No, I did not, because, Millard, the government has come up, this corporation, by virtue of, Millard, the rule 17 of the 2022 rules, Millard, they are issuing a new tender. I said that without considering, because there is
That I understand, but then in the interregnum, did you lift sand?
No.
After
till
your
Miller,
validity period expired,
the question Miller does not arise.
you didn't.
No. After the expiry Miller, I could not.
You could not.
And I did not.
Very well.
And Miller, the judgment Miller, which lend assistance Miller, subject to correction. একটা করে copy, দুটো copy চলে যাচ্ছে। না ছিঁড়ে গেছে এটা। I'm sorry Miller. হ্যাঁ, সাইটেশনটা হচ্ছে 2023 SCC online Calcutta 4791 Radharaman. Paragraph 3, 11, 12. The petitioner has referred to clause 5 of the part 9 of the lease in favor of the petitioner, which demonstrate the failure on the part of the lessee, which I have read, Millard. I am skipping. Now, Millard, paragraph 11, it also says, Millard, the lease was executed on such and such, a notification issued on such and such, imposed restriction on movement of all kinds of heavy loaded goods vehicles through Golshi to Gogram Road, such and such. The restriction was withdrawn by a notification issued on Millard, narrating the entire incident. And there is no connecting route. So Millard, they could not take out sand. 12, the Google map relied upon by the respondent does not clearly indicate any alternative route to the leasehold plot. And in view of the admission made by the authority as recorded earlier, the map cannot be of any assistance to the respondent in this matter. At this juncture, it is pertinent to refer to clause 5 of part 9 of this lease, which enumerates if through force measure the fulfillment by the lessee of any of the terms and conditions of the lease be delayed, the period of such delay shall be. In the case in hand, then Miller 22-23. It has been 21. Even at the cost of reiteration, it is necessary to record that the provision of 2021 policy is admittedly not applicable to the present case. As such, there is no restraint on the authority in extending the lease period in view of the said policy. It has also been held.
That stage has not arrived here. There is no rejection as such.
No rejection at the same time. But Millard, if the tender, Millard,
I understand.
and the petition will be.
Admittedly, the petitioner has not submitted bid in pursuant to the tender floated by my client. Firstly, on the identical issue, a writ petition was dismissed by the coordinated bench of this honorable court, challenging which appeal was carried out. My learned senior friend appeared in this appeal.
Yes,
that appeal
that is on a different. That is on a different footing.
I can distinguish the judgment which my learned friend has relied upon because I appeared.
Why are you keeping the application of the
Millard.
I have not
Millard.
Submitted to the state authority. I am for the corporation. By virtue of 2021 rules, I have been designated as the nodal agency for allocation of coal block. Now the application was made to the state authority. Additional
not to you,
not to me.
In Millard, I am MDO. My learned friend is not correctly instructed. In this matter, where I lost in the single bench and a division bench, dear Millard, the question of force measure did not apply. Dear Millard, I did not participate in the tender process. I did not apply for the selection of the MDO modified developer mining project. And dear Millard, the division bench says you are sitting idle. You go. You should be out of court. I lost in 2 cases. But in this case, Millard, I am a selected bidder. I was selected by the government.
No. Possibly my Latin friend is not correct. He selected pursuant to the old rule, not by the person.
I am not saying so.
Also, he did not participate in the tender.
Said, Millard, that I am not claiming, Millard, the entire block. I am saying the block that was allotted to me, I am confined to my case only, Lease. I said that there was a force measure clause. Millard, I have narrated the incident. If this incident, Millard, coming within the...
for this state?
Mr. Tonay Chakraborty for this
Yes.
state, the application was submitted.
114. Pending before the DM and
well, it has not been disposed of. There is already a pending writ petition which was never moved. Well, at paragraph 27, the writ petition they are mentioning for extension of time, they have never moved it till now.
Maybe. So you will sit right.
No, I cannot say anything. Should have been. Should have been. They should have.
And in the meantime, the authority has come up with a fresh tender notice, and the petitioner has not participated on the impression that his application is pending.
Application and he's waiting for 2 years.
Not 2 years.
Yes, 2023 writ petition.
November 2023
writ petition. He's moving for.
The application was submitted in November 2023.
It was valid till March 24, you said?
Yes, it was till March 2024.
He filed a writ petition before that in 2023. Thereafter, he did not move that writ petition. I just checked, there is no order against this writ petition. So, they were.
And how many days business did he lose? 69 working days only, not much.
No. 553 days. I was only allowed, Millard, para 23, Millard. On 11th May, the petitioner received a royalty certificate, and I categorically mentioned, Millard, 23.
And one thing, this application has been filed.
And paragraph 37, Millard, only one.
could be come under group 1 because it's the sand mining activities or mining.
Then this bench is taking up urgent matters of.
In the presentation form,
let
it
me
has
see.
been indicated as group 9.
Milord, only one thing, Milord, paragraph 24. Milord, since I am processed, I am Milord. Then Milord, in group 1, he will say it is ultimately a challenge is thrown to the tender matter, so should go to the group 1. 9.
But now I am holding determination
I
of
have said
that
that in the
bench also.
presentation form,
So
there
you
should
are
be a
saved.
correction. Otherwise, it should be. I know that your
Milord,
district is taking up.
no,
group 1.
Milord,
I
state has only 2 objections. Either it is not maintainable or no determination.
Wait.
Very.
I have not said this, Mr.
No.
Wait, it's a
no.
general statement. Don't
General
take it that
statement.
way.
I also used to do
Yes.
this when I was in state panel.
Yes. So
I am not free from all.
right.
I'm saying that I am guilty of this.
Tell me.
No, I suffered
Tell
these
me
vices.
one thing.
26.
Why did you not move your writ petition which you filed?
This fact I cannot. I have no explanation to offer. I cannot say. I am only moving this petition. If I make any statement, Milord, it will be untrue. I don't know.
Because in the
Paragraph
pleadings,
24.
they state that lease is
23, 24. Mr. Shaha, please allow me only 1 minute.
Least of dates, they have stated their
Yes,
leases.
paragraph 23, 24, Milord, that is sufficient for your lordship's query to answer, Milord. Kindly cease. I have deposited the entire amount. Milord, government will enjoy my money.
And one thing, my lord, the judgment which Mr. My learned senior friend has cited out, I appear in this matter. Because if there are totally factually different matter. In that particular case, there was a restriction imposed by the district magistrate for flying of heavy vehicles. And there was a recommendation of the district magistrate that because of the closure of the road, these mining activities of the petitioner was affected. On the basis of that recommendation, this order was passed. Lordship, I was
All
there.
right, but here he invokes the force majeure clause.
Lordship, the authority will, if they find that the petitioner is
I'll
entitled, or they will make arrangement.
ঘুরে ফিরে তো একই জায়গায় এলি।
Ultimately, they have to come.
Milord, kindly record this judgment which has shown that I did not show to your lordships, Milord, because
he appeared in that
yes, Milord, I need to face it, Milord. Kindly say, record this. Yes. He is saying that it is a suppression. When it is a question, no, when it is a question of honesty, I am the last person to tolerate.
Suppression
No. You said that you said that I appear.
Wait, Mr. Bose.
Milord, may I take my lords kindly one minute?
Yes, it's better you leave.
I feel like how.
It's the the petitioner was awarded a contract. Is it a contract or a lease deed?
Lease deed, my lord.
And she awarded a lease deed.
তারপর
For
first auction, thereafter the listing.
Lease deed হয়েছে।
lifting sand. In the year 2017 for a period of 5 years. Paragraph. Because of the COVID, as COVID intervened in the midst of the lease period, the petitioner lost valuable days on which he could not lift the sand. Stop. The lease was valid till March 2024. Stop. An application seeking extension of the lease period was filed by the petitioner in November 2023 before the district magistrate and collector. The same is pending till date. Stop. The petitioner is presently aggrieved as the West Bengal Mineral Development and Trading Corporation Limited is taking steps to float tender offering the same sand mine for auction. Stop paragraph. The petitioner submits that his claim for claim now his prayer for renewal will become infructuous if the tender is permitted to be proceeded with.
It is
Stop.
for extension, not for renewal.
আচ্ছা ওখানে বললাম কি রিনিউয়াল এক্সটেনশন ঠিক আছে তারপর হচ্ছে the petitioner relies upon clause 5 of the
Page 75, ma'am.
general provisions of the contract. Where does it start from? Page
75, your lordship, paragraph
well,
5.
75 I've seen. Where from
Paragraph
the
5,
My lord,
madam.
70, my lord, for the
no 70
Paragraph 5.
general provisions, the chapter.
that is part 9. Where is part 1?
Part
The
part
listing
9,
part
paragraph
starts from
5, your lordship.
page number 31. 31.
31.
These two, 31 থেকে।
Part 1, page 36.
31 থেকে listed.
আচ্ছা কি বললাম
Clause 5.
General provisions of the
general provisions within bracket provisions enumerated in part 9 of the indenture of lease dated 8th March 2019 where there is a provision
Clause 5, your lordship.
to fulfill the terms and conditions of the lease due to force majeure. 75 100 এখানে stop. It has been submitted that as the COVID was an unprecedented situation absolutely beyond the control of the petitioner. Accordingly, the time period lost during the COVID period ought to be allowed to the petitioner by way of an extension. Stop. Paragraph. Learned advocate representing the corporation, that is the tender issuing authority, submits that no prayer was made before the said authority seeking extension of the lease period. Stop. Paragraph. Learned advocate representing the state respondents is not aware as to why the application seeking renewal made by the petitioner has been kept pending. Top paragraph. It has been brought to the notice of the court that a previous writ petition filed by the petitioner, paragraph
27, my lord.
being WPA 28181 of 2023, seeking extension of the lease period, is pending consideration, and the petitioner never took any steps to get the same heard. Stop. Paragraph. The what is the position of the tender now?
So the tender today is opening because
Alright.
bid submission has already been, because day before yesterday, Lordship took up on dispose of one matter challenging the same self
Same.
tender.
আচ্ছা আচ্ছা লিখুন তো যে
Today is the opening of
in respect of the current tender, comma, the petitioner has not submitted his bid.
Yes.
Stop. Today is the date for opening of the tender bid. Stop. Paragraph. The district magistrate and the collector is directed to consider the prayer of the petitioner for extension of the lease period in accordance with the terms and conditions of the lease deed, and particularly the force majeure clause. After giving an opportunity of hearing to the petitioner to place documents in support of its claim, at the earliest, but positively within a period of 14 days, Mr. Chakraborty, 14 days from the date of communication of this order. Stop paragraph. Till a decision is taken by the district magistrate and collector, comma, the corporation is restrained from issuing any work order in terms of the block in respect of the in terms in respect of the block where the lease was granted in favor of the petitioner. ঠিক আছে? Disposed. I am not referring to any of the judgments shown by any of the parties. এটা ওনাকে, এটা এনাকে।
Yeah, I appear for the petitioner. The last occasion, my lord, has directed us to serve on the government pleader, my lord. We have served on the office.
We are for the respondent
Yes.
Bengal Fisheries, and my seniors are not in town. They are away for medical purposes. So I'm praying for time. Please, the matter be kept after 28.
First of all, you tell me, why is your band in such a state?
Sorry,
It should not be.
I'm just changing it right now.
This cuts a very poor impression of the institution, not of a particular member. Right? So please be conscious. Who are you representing?
Bengal Fisheries.
Bengal Fisheries. Who is issuing the, who has called for the tender? Fisheries
Bengal
Corporation.
Fisheries has called for a tender, lordship. We have been allotted a cold storage inside their compound in Purbo Medinipur. Lordship, they used to raise bills on us for as per the reading of the submitter at the rate of ₹10. Lordship, from August 2024, they had revised it 50% at the rate of ₹15. Lordship, that is the issue of challenge. Lordship, I am ready to pay ₹10. Lordship may direct them to consider my representation, and I shall put in the money. Let them not disconnect in the meantime.
Who is going to disconnect? The Fisheries
The
Corporation?
Fisheries Corporation, who was
And how is the fishery giving electricity connection to you?
by submitter.
Are
As-
you the tenant of the fishery?
No, but I'm the allottee under their in the compound. It is
All
a
right. Allottee in the compound allotted by
with
the-
respect to a cold storage allotted by Fisheries Corporation in a tender. Lordship, will see the tender. One of the tender is at page 20.
Are they taking immediate steps?
Lordship, there is a threat of disconnection which is at page 131. The last paragraph. It is a last reminder to you for clear corresponding dues.
13 lakh is due?
13
Since
lakhs, Lordship. As if it is ₹10, Lordship, it would be around 8 lakhs.
Even then, there is so much of due. Why have you not paid?
Lordship,
Why will they
since the
put it
revision,
there?
Lordship, since the revision, Lordship,
Had the revision not been there, you say it would have been 8 lakh?
Lordship, I shall be paying,
What
but
do you mean to say you shall be paying? Why have you not paid?
Lordship, only from August 2024 it was revised.
That is 8 to 13. What about the 8 that is due?
8 to 13, my lord.
The Right.
The 8, Lordship,
Pay
8 I am ready to pay, Lordship, but we were corresponding with the
Pay it. I will not interfere till you pay.
Lordship kindly records.
Nothing.
Lordship kindly records my undertaking. I shall
No.
pay today itself, my
I
lord.
will not record your undertaking. I'll recording the undertaking that the corporation accommodation has been sought for. Nothing. You pay. No one is stopping you to pay.
Lordship,
Please
I am
stop.
paying, my lord, and my lord kindly records that, my lord.
An accommodation has been sought for by the learned advocate representing the West Bengal Fisheries Development Corporation. When is the council due?
After 28th, they will be back.
28th February.
28th January.
28th.
Acha. Stop. The petitioner apprehends disconnection by the corporation. Disconnection of electricity line by the corporation. Stop. On the prayer of the learned advocate representing the corporation, the matter stands adjourned till 28th.
After 28th,
আর
my lord.
29th করে দিন 29 ঠিক আছে January. Stop. Pendency of the writ petition will not stand
Kindly
in the
records
way.
without prejudice. Only one thing. I shall be paying without prejudice.
Will not stand in the way of the petitioner from clearing the
Admitted dues, my lord.
dues.
Admitted dues, my lord.
No qualification. Admitted, not admitted, nothing. Only dues. Call the next matter.
Which will be paid without prejudice. Lordship will record that, my lord.
The matter is pending with prejudice, without prejudice, the court will see. Till 8.
Lordship has kept it on Monday.
No, 29th, Wednesday.
Very well.
Item 8.
May it please your lordship, my lord, I appear for the petitioner. The petitioner is a hospital, my lord, which was requisitioned during COVID. My lord, the bills have been raised, claims have been made starting from 16th of September 2020. And my lord, repeatedly we have been writing letters, bringing it to their notice that these are the claims, these are the computations. Please, they have not even responded to it. My lord, the writ petition may kindly be disposed of, directing the government or directing the CMOH, my lord, to take a decision on my representation as to how much we are entitled to. That is the only sum and substance of the writ petition. It was filed in 2023. I'm showing your lordship, my lord, one by one the document. My lord, please come to page 176.
My lord, receiving this, my lord, the quantification of the admissible dues, my lord, have been made, lordship. It has been, my lord, may I respectfully hand over the report of the, this is not to be placed, this is a report of the DM, my lord, dated, my lord, 3rd October 2023, lordship. May I respectfully invite your lordship, my lord, to page 2 of the report, lordship.
And if he is circulating something, my lord, may a copy be handed over?
I shall. Wait, Mr. Bhattacharya. My lord, kindly, my lord, come to 3rd paragraph. Record speaks further that out of the claim of rupees 3 crore 35 and odd, rupees 74 lakh 98 has been determined by the COMH as amount admissible, and as rupees 17 lakh 61 has been given as advance. The amount due is to be paid 57 so and so. So this is the quantification made, 74 lakh and odd. 17 lakh has been paid, and that is also during the pendency of this writ application. He has accepted that payment, because it was affirmed on 15 September 2023, and amount paid was on 27 September. And the rest, about the rest amount, kindly have a look at the next paragraph. Latest information as received from the COMH is that the matter is pending with the health and so for according approval. So this is the report I have received, my lord, on 3rd October 2023. And lastly, the COMH is also giving the same report with regard to the status of reviewing. So, my lord, this is my lord, lordship.
May I explore these documents and come back to your lordship on Monday or any time convenient to your
Quantification already
lordship?
done.
No, quantification might have been done. We have not.
No,
been
but in
made
your
aware.
petition, nowhere you have said about the quantification. Simply, his.
The petitioner.
I have not said about quantification, my lord. That is my representation.
Payment of certain claim. From the CMOH Paschim Bardhaman. Stop. A representation has been filed by the petitioner, which is alleged to be kept pending. Stop. Paragraph. Learned advocate representing the state respondents has obtained instruction from the district magistrate Paschim Bardhaman, which which mentions that petitioner has claimed a sum of rupees 3,35,93,200 as due and payable. Stop. Out of the aforesaid amount, the admissible dues of the petitioner has been found to be rupees 74,98,650. Stop. Out of the admissible amount, a sum of rupees 17,61,476 has already been paid to the petitioner as advance, and the current due is rupees 57,37,174. Stop. Paragraph. The report mentions that the matter is pending with the Health and Family Welfare Department for according approval, for which the payment could not be made. Stop. Paragraph. As it appears that a portion of the petitioner's claim has already been found to be admitted, the concerned authority ought to take prompt necessary steps for disbursal of the admitted amount at the earliest, but positively within a period of 16 weeks from the date of communication of this order. Paragraph. As regards the amount which has not been admitted by the authority, it will be open for the petitioner to seek remedy competent forum. Stop. The writ petition stands disposed of. Instruction retained with the records.
We were this computation thing at the time of computation. We were not heard. We were not given any opportunity. They have computed it unilaterally. Your lordship desires that we be paid the admitted amount. Receipt of that admitted amount may be recorded to be. Assuming they pay, it should be without prejudice to our rights and contentions. That is one. And two, I am before my lord, let your lordship may very kindly decide, instead of relegating me to some other appropriate forum. This is the appropriate forum. It is in terms of their guidelines, that there are certain guidelines I have not invited your lordship's attention to.
The figures mentioned in the report and the amount which may be paid to the petitioner may be accepted by the petitioner without prejudice to the rights and contentions of either of the parties.
Regarding the other part of the matter,
but he has accepted the part
affidavit.
Maybe he will accept the whole payment. Why make part? Call the
Lordship,
next matter.
may I pray for one line to be recorded? I have served a copy of the instruction to my learned.
Let be it recorded that a copy of the calculation, not the calculation, the instruction forwarded by the district magistrate has been served upon the learned advocate representing the petitioner.
Lordship.
Only one humble request. Kindly keeps the matter pending and directs affidavit. Where will I go?
10.
As your lordship, please.
My lordship, I am for the petitioner, my lord.
Yes.
Here, my lord, petitioner.
9.
My lord,
Yes.
petitioner is the scheduled caste, my lord. She married, my lord, one Saurabh Patra, my lord. That is, he's in the Mahisha in the general caste category, my lord. My lord, her son, my lord, Sohardo Patra, my lord, petitioner made an application for scheduled caste certificate. She lives and resides with her paternal house. But my lord, the authority, my lord, without behind her back, my lord, inquiry has been made and rejected her prayer. My lord, without my lord relying upon the
mother is scheduled caste.
Mother is the scheduled caste.
Father is general caste.
Father is the general caste, my lord.
And you want a SC certificate?
Yes, my lord. Because my lord, I am referring, my lord, the circular and the decision led by the Honorable Supreme Court. Here, my lord, this.
Initially, may I tell one thing? But yes, I know my learned friend may refer the notification of the Union of India of 3rd October 2019. Before that, 2019, I think. That when this problem the cropped up and the Supreme Court delivered judgment that when the single mother and or the
Yes, ma'am,
child
that
is brought up
I brought up
with the
brought the
mother.
judgment.
And mother is a civil caste community, belong to civil caste community, but not the father general community.
Well, young come.
Now, there are several guidelines that how to be dealt with that. But before that, Lordship, now with the passage of time, my lord, the boy is now, my lord, 19 years and 6 months old. Now, my lord, when that application was made by the mother, maybe that, my lord, the boy was, my lord, he was a minor. But now, my lord, the writ petition filed by mother on behalf of, my lord, the adult son, my lord, she kindly consider whether it is maintainable. The son is not a party. My lord, the mother is not an aggrieved person, first of all. Now, Lord, she kindly consider this aspect also. That whether writ petition.
Yes, why has the mother
behind,
come?
behind her back, my lord, without any intimation.
Now, the son should make an application as per the, my lord, the act and the rule. The person who is willing to be that I belong to that community, he shall make an application.
He shall assert his right.
Identification Act, as per the act. And my lord, and my lord, it appears also from this notification that my lord, he has to, my lord, satisfy many things, that how long his mother or he is being brought up.
Yes, this I understand. Why is the
At the time of application, my lord, he was minor, my lord.
right?
And
But
not
now
only
the child has become a major.
well, major.
So he is the aggrieved party. Let him make application. The authority will consider. Where is the rejection?
Rejection
is not
at,
to be
my lord,
my lord, but one
page
thing.
34.
My lord, it is, and the petitioner made application in 2022.
The passage of time.
Please come.
And my lord, behind my back, my lord,
The petitioner,
my lord, liberty given
as
And my lord,
mother.
This fact appears from, my lord, page number 35, paragraph number 2. That is, my lord, a representation, my lord, made by mother and stating that the son was born on 10th of June 2005. That means today, my lord, he is now, my lord, the 19 years and 6 months old.
2019, but application made, my lord, 2022, my lord. That is
Petitioner as mother
not major, my lord, at that time.
Applied for obtaining a reservation, caste reservation certificate in favor of her minor son. Stop. The petitioner is a member of the scheduled caste community, but her husband, that is the father of the child, is
Kindly have a look, section 4 of
from the general caste.
আপনার সুবিধা হবে তাদের।
ঠিক আছে। Identification next.
The prayer of the mother for issuance of the scheduled caste certificate in favor of her son stood rejected. Stop. By the period of time, by now, the son of the petitioner has already attained majority. Stop. The mother submits that the certificate was issued in favor of her son behind her back without proper inquiry. Stop. Prayer has been made to direct the authority to issue a scheduled caste certificate in favor of the son. Paragraph. The prayer of the petitioner has been opposed by the learned counsel representing the state respondents. Stop. It has been submitted that the writ petition at the end of the mother, the writ petition by the mother, will not be maintainable as the son is presently a major and the son may be treated as an aggrieved party. Stop. Paragraph. Admittedly, it appears that the son is more than 19 years of age and he can maintain a writ petition independently. Stop. Paragraph. If the son of the petitioner is aggrieved by the certificate which was issued in his favor when he was a minor, comma, it will be open for him to make application before the concerned authority.
In terms of section 4 and
4(1).
4, that the person, any person who wants to, section 4 of the Identification Act. And section 5 is the authority.
If the son of the petitioner is agreed by the certificate which was issued in his favor when he was a minor, it will be open for him to make application before the concerned authority.
In terms of the West Bengal SC and ST within bracket Identification Act, 1994. Stop paragraph.
Jurisdiction point of view.
According to the provisions of section 4 of the aforesaid act, any person belonging to any of the tribe, 3. This is scheduled caste, isn't it?
Scheduled caste married.
3.
Is it-
Section
is it-
3 of 4 bollam to 3 of
He lives with a
any
mother. and
person
scheduled caste.
belonging to any of the castes, races or tribes specified in part XIII of the schedule of the constitution, bracket open, scheduled castes, bracket close, order, and is a resident in the locality specified in relation to him in that part of that scheduled, may be identified, by a certificate, to be a member of the scheduled castes. Stop.
And
paragraph.
authority is the 4 manner, section 5. Authority is supposed possibly section 5.
Very well. The son of the petitioner may avail the aforesaid provision and make application before the competent authority. Stop. In the event such an application is made, the same shall be considered in accordance with
On
law.
the decision of the Honorable Supreme Court also.
Earliest. Why Supreme Court? At the earliest, in line with the
Decision of the Honorable Supreme Court, my lord.
in line with the
Notification.
guidelines issued by the
guideline.
Government of India, Ministry of Social Justice and Empowerment, Department of Social Justice and Empowerment, dated 3rd October 2019.
না ঠিকই আছে একটা ঠিকই
Misuse করলেন আপনি।
ঠিক আছে?
এত বছর ধরে ফেলে রেখে দিয়ে এখন আপনি টেকনিক্যালিটিস
2019, after giving reasonable opportunity of hearing to the applicant. Disposed. Service is taken on record.
ছেলে মেজর হয়ে গেছে, অ্যাপ্লিকেশন হবে কি করে? বোঝে না।
Item penal or IAP for the petitioner.
থাকবে বইটা?
But IAP for the petitioner, my lord. Well, this is an application where the petitioner is seeking to be Muslim marriage registrar and Qazi. Now, my lord, initially, my lord, the petitioner's father, who was, my lord, a temporary Muslim marriage registrar and Qazi.
বলবো আমি to cut short, I need one instruction in the matter. May it be kept on Friday next lordship. Because
That is
3
Friday.
consecutive rejection orders, 3
There are
consecutive.
3 consecutive rejection orders. The first one only speaks. The latter 2, my lord, only says they've earlier
Matter
rejected.
relates to appointment of MMR and Qazi. Stop. Learned advocate representing the state respondent seeks time to take instruction. Stop. List on
Next
31st.
Friday lordship.
Around 31st.
Great.
Was service taken on record.
May I please, Lord, this is my affidavit of service, my lord.
State.
My lord, this matters relates to, my lord, the midday meal project of a, my lord, the particular school. What happened here, my lord? The project was running, my lord, with the insufficient funds and, my lord, irregularities to, my lord, to disburse the fund. No, my lord, the issue has not cropped up today, my lord. It has cropped up from 2019. Several letter I have wrote, my lord. They all are the part of my writ petition. Presently, my lord, I have informed the DM, my lord. In this situation, it is not possible for me to continue with the project, my lord. Otherwise, I have to close the project. But, my lord, the local people who are there, my lord, they were not, my lord, supposed to, my lord, ask question to the DM or BDO, my lord. They will ask question to me. From my pocket, my lord, I am running this project, my lord.
Payment not being made.
No, my lord, kindly see. Kindly see my one document, my lord, last document, my lord. I will see other in detail. Last, which was, my lord, is page 21, perhaps, my lord. 21. That is in 2022. 2022. Thereafter, this writ petition was filed, my lord.
1 minute.
My lord, instructions have not yet been received. Kindly take it on next Friday, my lord.
Next Friday? Why?
Or next Wednesday, my lord.
There is
Because the school doesn't have the fund for the midday meal projects.
no cook, no assistance, nothing, my lord. In every letter, I have mentioned to every authority. Now I am running from my pocket, my lord, this project, my lord. Otherwise, my lord, the local people will, my lord.
You are the
headmaster.
The petitioner is the headmaster of a primary school. Stop. He alleges that because of non-payment of fund, non-disbursal of fund in favor of this school, comma, he is not in a position to continue with the midday meal projects. Stop. Repeated representations were made before the block development officer Farakka block
As well as the DM, my lord.
and the district
DM.
magistrate Murshidabad, comma, none has been considered. Stop. Learned advocate representing the state respondent seeks time to take instruction. Stop. List on 31st, next Friday. Written instruction shall be obtained as to when the payment will be made in favor of the petitioner. And stop. The reason for non-disbursal of fund for such a long period of time shall also be disclosed in the instruction. Next one is also same.
No. Some, my lord, that's related to midday meal.
All right.
My lord, affidavit of service be kept.
Service is taken on record. Next.
My lord, দাদা এইটা তুলে নিন, এই affidavit service এই সার্ভিসটা তুলে নিন, এইটা তুলে নিন আগের সার্ভিস এটা। হ্যাঁ, this is my affidavit. My lord,
state
my lord, here, my lord, this is also relates to, my lord, the midday meal project, my lord.
Petitioner is the headmaster.
Headmaster, before your lordship, here the problem is that, my lord, headmaster is in charge of the, my lord, whole management as per, my lord, the notification of statute, my lord. The mobile number, SMS, all which will come to the in the phone number of the headmaster. He will every day, my lord, report to the BDO. Thereafter, my lord, what happened? Subsequently, BDO has, my lord, engaged another person, delegates the power to the another teacher for continuing the project. But, my lord, the rule says that this power can be delegated by only the headmaster. Headmaster can delegate power to the other teacher. But in the choice of the block development officer, is his choice. He cannot, my lord, appoint anyone. Or
it has to go through the BDO, through the headmaster.
This is the rule, my lord. Just, my lord, pardon me, my lord. I have marked, my lord, that last duties portion, my lord. Last. Therefore, my lord, he is the authority. My representation was there. Without bypassing the headmaster, my lord, someone has not been appointed. Someone has not been given the charge.
Lordship, actually here the case is completely different. Here the headmaster suffered an accident and he wrote to the BDO saying that he will not be able to take care of the school and the midday meal project and therefore to hand it over to somebody else. Accordingly, that was done for that time period of time. After that, once he recovered, he joined the school back. And now he wants the midday meal service given back to him. However, some other teacher who was appointed was already conducting that service successfully. Now, this is the instruction as per, this is a very old matter, Lordship. This is as per 22/4/2024, where the instruction says that the person who was given the charge of this midday meal, he has also retired. Thereafter, what is the situation, Your Lordship?
So
I
it
will
has
have
to
to
go
just-
back to the headmaster
Yes, my lord,
because
that
there is no other option.
I will just take
Page-
instruction and
page
submit.
23, my my representation, I said that I was in, my lord, hospitalized. Thereafter, my lord, I
is
came
the
to, now I am want to, my lord,
headmaster
take
of
back
a
my
primary
charge.
school. And because of his designation, he is the competent authority to be in charge of the midday meal project of the school. As the petitioner suffered an accident, he was not in a position to perform the duty of the midday meal scheme.
That is in 2020.
Stop. After his recovery, he sought for handing over the documents in connection with the midday meal project to him, but the same was not done. Stop. The during the absence of the petitioner, the block development officer handed over charge to a different teacher of the subject school to ensure that the project is not stalled in the midway and the same remains functional. Stop. The prayer has been made to direct the block development officer to hand over the charge to the petitioner once again. Stop paragraph. Learned counsel representing the state respondents submits upon instruction that the charge was handed over to a different teacher because of the petitioner was indisposed. Stop. The person to whom the charge was handed over has retired in the meantime. Stop paragraph.
No, my lord, he retired in 2023, my lord, in July 2023.
Acha,
Thereafter,
retired,
new man has been given.
retired in 2023. ঠিক আছে নেক্সট হচ্ছে
আমি তো
as in terms of the guidelines published by the school education department, the duties and responsibilities of the midday meal scheme are specified. Accordingly, the block development officer is directed to take necessary steps in the matter. Stop. Where is the representation?
My lord, page that is in coming from page 23, my lord. 23 page.
Which one you want to be considered?
My lord, 23, 24, my lord, also, my lord.
Acha.
Same.
A representation from the petitioner is pending consideration at the end of the block development officer. Stop. Let the same be considered in accordance with the prevailing guidelines at the earliest, but positively within a period of 4 weeks from the date of communication of this order. Necessary consequential steps shall be taken by the block development officer.
My lord, may I, my lord, 24 is order letter dated 12 December 2023 and 25 is, my lord, I prayed for my lord giving me charge, that is 8 January 24.
Very well. Learned advocate for the petitioner is directed to forward a copy of the representation dated 8th January 2024 along with all supporting documents to the block development officer at the time of communicating the order of the court.
Grateful, ma'am.
Instruction.
My lord, the service we kept with the record. But may I take, my lord, may I take back the rule, notification?
Take back?
The notification which I handed.
Yes, yes. Do you have a written instruction?
Yes,
It is, actually came by a soft copy. It isn't
So what? Doesn't matter. Whatever is there, you please hand over.
This is lordship, paravise comments, lordship.
Just paravise.
Yes, yes.
13, this is my application, my lord. These are the services, my lord. Initially it was served, mentioning notices. Thereafter, after mentioning it was allowed, I have already served them. My lord, this
Court Calcutta.
yes, this is a petitioner is an unfortunate person. Since 1998, he has been, my lord, having cases under sections under Arbitration and Conciliation Act before the City Civil Court at Calcutta. My lord, records of these cases pertaining to only one issue, one truck, which was his livelihood, have been misplaced, not found. Informations has been filed by the petitioners seeking the records. Thereafter, petitions.
Was any notice of upgradation given?
Yes. I have, my lord, served the notices also for upgradation. Thereafter, upon being allowed with the mentioning, my lord, I have again intimated the authorities.
What is the relief that he was?
And I was seeking, my lord, information with regard to my cases, which were there with the authorities. And during the pendency of those cases, my lord, my trucks have been taken away by the financer and it has been sold out. But neither the records are available with the courts, and neither any dates has been there. But I was beseeching before this honorable court that let the records be at least traced out so that I can take steps in the matter, my lord.
Where are your representation?
My lord, my representation starts from, my lord, page 39. These are representations, and page 52 onwards are the RTI applications, which was also not answered.
If RTI is not answered, there is an appellate forum.
Yes, my lord, but the petitioner, since it's, my lord, absolutely in a distressed condition, my lord, since the RTI applications, thereafter it will be, my lord, we had kindly seized the information slips that I have filed, my lord, since 2022. No replies. Thereafter, applications being made under section 151, it was not taken because records were not traced.
See, if the proceeding is pending, records could not be traced, the civil revision jurisdiction is there.
My lord,
Here.
my lord, civil revisions, my lord, subject to corrections, my lord, I have all, my lord, in this writ petition, I had prayed for invocation of rule Article 226 as well as Article 227. Because of this reason, my lord, no records have been traced, my lord. I cannot file those cases before the honorable court taking up civil revisional matters, my lord.
Can certainly file. Please do not.
My lord, it is as per my understanding goes, my lord. I was, my lord, and this RTI applications has also not been answered.
Then go before the appellate forum.
My lord, kindly appreciates the my lord, agony of this gentleman, my lord, who has lost everything, and the records of the cases are not being
You
traced.
kindly appreciate the limitation of the court. Please come. None represents the respondents. Step. Let a further notice be served upon the learned registrar, City Civil Court at Calcutta. Intimating that the matter will be relisted on 31st. A report shall be filed by the registrar giving the details of the miscase number 3887 of 1998. This is the case?
My lord, there are 4 cases pertaining to same issues, my lord. I have given the list in the writ petitions itself. That it's at page 4 of the writ petition, paragraph 5, pertaining to same vehicle, but there are section 9, section 34, two cases and subsequent miscases.
এই চারটে কেস দিয়ে দেবেন তো ঠিক আছে 4 paragraph 5.
Grateful, my lord.
Service and the notices served upon the respondents be retained with the record.
Yes.
Your Lordship, I am for the petitioner.
Yeah. State.
Your Lordship, may I file the affidavit of service?
Union of India, But they are praying for pay fixation, perhaps, my lord.
Your Lordship, in this matter, the petitioner,
What is your friend?
purchased a vehicle, Your Lordship.
কোনটা বলছেন? দ্রুত লিখে দেন, my lord.
No, matter.
Pardon me, my lord, that is.
Yes.
Your Lordship, the petitioner purchased a vehicle in 2019, Your Lordship. And Your Lordship, I have one more indulgence, Your Lordship. Your Lordship, actually the draft of this petition is not at all well, Your Lordship. So, Your Lordship, I'll just state the facts.
No, you cannot proceed in this manner. The drafting is not well. You will say the facts. Is the petition defective? Or it's all right? Can it proceed in the manner where it is?
Yes, Your Lordship. Your Lordship,
Who are you representing?
State.
State. Your grievance is against?
The HDB Financial Services Limited, the respondent number 3, Your Lordship.
Will the writ petition be maintainable against this HDB Financial?
Your Lordship.
Why?
Your Lordship, in this matter,
Why and how will the writ petition be maintainable against this party?
because the financial institution sanctioned the loan
So what?
by which I
There
had
may be so many
purchased the vehicle.
So many private institutions, non-banking financial institutions, those who give loans to the purchasers. And will the writ petition be maintainable?
Your Lordship, just one thing, Your Lordship. In page number 46, Your Lordship. Your Lordship, the petitioner has paid all the installments.
Can the writ court look into all these things? You overcome this difficulty first.
Lordship,
Is anybody leading you?
I am being led by Miss Debolina Sarkar.
Where is she?
She's a bit unwell, Your Lordship.
Monday will be all right with her? I'll make it not today.
Lordship.
Try to meet the point as to how the writ petition will be maintainable. All right?
Lordship. Obliged, Your Lordship.
To allow the learned advocate representing the petitioner to come prepared in the matter. This is the same. I'll keep it on next Friday. You get more time.
Lordship.
31st.
Okay, 15, I'm being led by Mr. Kollol Mondol. Lordship, due to some personal difficulty, he could not come to the court today. I'm praying for just not today, Your Lordship.
What is the matter about?
Lordship, this is a matter.
Did you serve the other side?
It has been served.
Dekhiye ek minute. Do you have the service with you?
Affidavit of service, I'm
No?
just
Yes.
not today, Your Lordship.
Very well, not today. I'm
Grateful.
ready.
Grateful.
Bring your other side also.
Lordship.
16, my lord, I am appearing for the petitioner.
My lord, I am for Union of India led by Mr. M.S. Tiwari, my lord.
This is the affidavit of service, my lord. My lord, the application is arising out of the Assisted Reproductive Technology Act, my lord. The petitioner 1 is the husband and petitioner number 2 is the wife, my lord. They have a couple, my lord, female child. In the last year, April 2024, the only female child has died. Thereafter, they took to intend to have a child, and being failure in the normal way, they took assistance of the Assisted Reproductive Technology Act, my lord. When they applied, they contacted the concerned clinic. They were otherwise, being the commissioner couple, they were otherwise eligible, medically fit, mentally fit, and financially fit. But they were, since there was the embargo under section 21G of the assisted reproductive.
I have passed a judgment.
Yes, my lord, but in this case, only commissioner couple. I have come before your lordship as a commissioning couple. Since there was no embargo in respect of commissioning couple, only the individual woman, man and woman. That is defined under section 2E1 and 2.
Give me the law once.
Yes, my lord.
My lord, the age is the bar, my lord.
Yes.
Yes, sir.
In respect on only individual woman and man, but no bar in respect of.
Are you aware of the judgment that has been delivered by this court?
My lord, not this court, but one Kerala court's judgment, my lord.
This bench has passed order.
Yes, my
Please
lord,
check
on
up.
the similar view by this honorable court has passed an order in respect, there was only bar in respect of woman. I have come before your lordship in respect of the petitioner number 1 being the husband.
Brief, to show me the judgment that that has been
Yes,
delivered
yes.
by this bench.
Yes. That is page 4 is the relevant portion, my lord. Here 2 question was arises. I have come within the purview of second question, my lord. That is relevant page is page 4. আমি আপনার ফোন নাম্বারটা নিয়ে দিয়ে দিচ্ছি। আমি সাইটেশনটা দিয়ে দিচ্ছি। Relevant page is page 4, my lord.
This bench judgment, not aware?
Yes, I am aware, my lord, but it is
You
not
didn't-
at present with me.
You go through the judgment.
My lord.
All right.
My lord.
Passed by a coordinate bench and this bench also.
My lord.
When will you come prepared?
My lord, your lordship, as your lordship pleases, my lord.
No, because she is in hurry. The days are passing.
Yes.
My lord, on Tuesday, if your lordship pleases, my
Very
lord.
well, Tuesday. Yes. Please come take this back to allow the parties to come ready with proper instruction. List the same on Tuesday. Service is taken on record. এটা ফেরত দিয়ে দিন।
Grateful, my lord.
Like to appear for the petitioner, my lord.
No, I am appearing for respondent number 1, Union of India.
I'm for the LIC.
This case has a peculiar facts and circumstances because your lordship will see that in the year 2006, IRDA had promulgated a regulation whereby micro insurance came into being. And in accordance with the regulation, agents were appointed in accordance with the statute who were empowered to appoint specific persons pursuant to the approval of the authority. Now, the software that was given to them was faulty to a certain extent. The system was offline system. They used to put the data entry in the system and send it to the LIC. Now, LIC was supposed to pay the commission on the premium that was paid pursuant to the policies that were obtained by these agents with the help of the specified person. Now, situation went so weird that despite payment of premium, the system did not record those. There were criminal cases against us. The specified persons were arrested. We had to pay fine stating that you have not uploaded the insurance premium. We had indicated in each and every possible situation where we have paid the money. We took up the issue before the IRDA, but no steps whatsoever were taken. I was beseeching your lordship that since a huge amount of funds that we have paid, it is public fund, not our money, has not been taken into account by the LIC, let IRDA, who is the regulatory authority, effectuate an inquiry into the particular issue. This is my most humble submission. May I come to those portions, your lordship? Lordship may come to page 11, para 14. Where the petitioner has stated that in order to regulate the micro insurance policy business, the LIC installed a software at computer of the petitioner, namely Micro Insurance Agency System database, Your Lordship. Thereafter, two insurances were to be taken by us. One was Jeevan Madhur, micro insurance table in the preceding paragraph 13 I have mentioned. Another was Jeevan Mangal, micro insurance, that was table number 198. These were the only two policies which at micro level we were asked to procure. We had procured, my lord, and Your Lordship, next comes to
Did you raise any objection before IRDA?
My lord, we have.
Where is it?
Lordship, kindly bears for a moment, Your Lordship. IRD ke koro nahi tumi chithi. Based on the complaints, we have received letters from the LIC, Your Lordship. Your Lordship comes to page 14 on page 244.
Who manages this software?
The LIC,
LIC.
Life Insurance Company. But the entire system, we are pursuant to the RTIs that we had given to them, stating that my records are with you and you are not paying commission. First year, as per the regulation, 20% commission was to be paid.
What is your role?
My role is to procure insurance from the
Yes.
people in the rural area,
Right.
Pay the premium to the LIC, and
Yes.
pursuant to the payment of the the premium, we were supposed to get 20% commission.
And you updated in the records.
We have
in the
updated
system.
in the system, which is not being reflected. We have faced criminal charges.
All right. If it is not reflected, where is the money flowing? Is the money flowing to
The
LIC?
insurance company. This is where it has to be gone into. This inquiry which I am seeking, Your Lordship, has the IRDA has to see what is happening with the money that I have paid to the LIC.
And what is the proof that you are paying the money?
Several representations, because it was in the
No, no,
system.
System, suppose.
My lord, I have given those. Your Lordship comes to pages.
How are the transactions made, in cash or in check or draft, or how? Online payment?
Online payment.
All online
That is on
payment.
record. The payments were made online.
The LIC cannot say that you've
No,
not paid.
no, my lord. If such be the case, let my case be dismissed with costs, Your Lordship.
The payment has been made.
Payment has been made.
You are not getting your commission because it is not being reflected
It's
in the
not
system.
only the part of the commission. There are the insureds who have not received the maturity amount even. They have even filed consumer cases against me. I'm in a very precarious situation entirely.
Your representation?
My lord. This is the RTI letter, representation data. Page 347. This is a reply to the RTI that they given. My representation is that page. That's it.
Yes.
Lordship, all the presentations were answered. Lordship, my prima facie submission is this writ application prima facie is not maintainable because it is a money claim. Secondly, Your Lordship, this scheme has closed by now because these claims, the petitioner by dint of which.
Now, what will be your submission with regard to the prayer of the petitioner for consideration of his representation by IRDA?
Lordship, LIC has replied to their representations, and those representations, they have not acted upon those representations at that point of time since 2014. So this scheme was initiated on 2007. Till 2014, the scheme was in existence. And all they were, whatever they were agreed, they placed the representations before the reply LICI. And my lord, if come to page 244, annexure P14, and several replies are also there on the part of the LICI. So they didn't take the endeavor to approach any of the forum to make the challenge or place their grievances. Now at this juncture in 2024, when the entire scheme has closed and the entire record is absolutely, because the scheme has closed. So at that point of time, at this juncture, Your Lordship, the payment regarding.
Lordship comes to page 256, Your Lordship. 256. It was a letter to the chairman of IRDA in 2011 itself.
11 representation cannot be considered now. You were not vigilant enough to proceed with your
My lord,
case.
we had filed a writ petition which was pending before the court at that point of time, which got dismissed.
Yes.
Thereafter, my lord, we took up another writ petition, but there were certain facts which were not.
on merits.
No, your lordship, not on merit, it was for default. So thereafter, another writ petition was filed when I was approached to appear in the matter, and finding that certain issues were not placed before the court, we withdrew the writ petition with liberty to file afresh, and thereafter we are before your lordship.
Those things, Your Lordship.
So the claim was there prior to 2011.
The entire situation went hayward from 2008 itself.
Yes, because she says that the scheme was valid from 2007
My
to
lord
14.
kindly understands my predicament that I'm facing even till today, that the person from whom we had taken money, that money is with the LIC. And I am being held up for that particular thing, and I have to pay them from my own resources. And the fund is lying with the insurance company till today. The scheme might have closed, my lord. But what has happened to the money which I have already paid to the insurance company?
Page 256, where is the receipt showing submission of this document?
My lord, the postal.
It doesn't show the date.
256 is.
My lord, I understand it's not there.
And today IRDA is not representing also. Your Lordship.
मेरे कोথায় পাঠিয়েছে? Page 259 is the mail that we had sent to them, my lord. This letter was sent even by mail.
This is 2012.
12. Again.
Anything thereafter?
Let me assess the lodge. Last RTI ছাড়া কিছু করোনি.
Yes. Can the Union of India be of any help?
My lord, I can only say that, my lord, as per latest judgment, my lord, Reed Court has the, my lord, jurisdiction to, my lord, take these matters, these monetary matters. What she has said, my lord, it is not maintainable, but it's maintainable.
No,
Let an inquiry be effectuated by RDA, my lord. My most humble submission.
Say all these things.
All allegations against LIC. What will the LIC do?
Lordship,
We have
the writ
nothing to do
petition
with
can be
Let-
considered as representation, and we can consider, but these are all
So many pages? Certainly not.
Let IRDA, my lord, effectuate an
I
inquiry.
included as a party, it seems. My lord.
Respondent number 2.
Respondent number 2. But
The
IRDA is not
petitioner
appearing.
prays for consideration of the representation filed before the chairman of the Insurance Regulatory Development Authority, within bracket Micro Insurance. Stop. Next, without going into the merit of the said representation. Now, going into the merit of the claim of the petitioner. The instant writ petition is disposed of by directing the respondent number 2 to consider the same in accordance with law after giving reasonable opportunity of hearing to all the necessary parties. Stop. A reasoned order shall be passed and communicated to the parties. Stop. Endeavor shall be taken to pass a final order in the matter at the earliest, but positively within a period of 4 months from the date of communication of all the communication of this order. Stop. It will be open for the petitioner to forward all relevant documents in support of its claim to the aforesaid respondent at the time of communicating the order of the court disposed.
Oblige you, lordship.
My lord, I'm for the petitioner. I'm not well, my lord.
My lord, I am appearing for respondent number 6.
You are not well.
Stomach disorder, my lord.
Stomach disorder, you are here in court?
Just I'm coming from toilet, my lord.
Not today.
Not today, my lord. Much obliged, my lord.
I am appealing for petitioner in this matter. My lord, I have served upon all the respondents, including the private respondents. Well, notice of upgradation also I have served, my lord.
Private respondent.
My lord. My lord, the petitioner before your lordship, my lord, is about 70 years old.
How many?
70. 70.
70.
70 years old, my lord. He is deprived of the water supply, my lord, since August 2024. Now, my lord,
এটা কোনটা দিলেন? এটা তো
the petitioner is 70 years old, my lord. He is a member of a welfare association, my lord. It's an apartment by a registered deed, my lord, executed on 11th of August 2004, my lord. He entered into the flat number 3 at block C of the apartment. Now, my lord, since April 2023, my lord, the lift facility and other facilities which were provided to all the members, that was stopped in respect of the entire block. There are 3 blocks, A, B, and C. In respect of block C, my lord, it has been stopped, including the petitioners. Now, my lord, on 30th of August 2024, the water supply was also stopped. Now, my lord, since 2022 onwards, there is no managing committee. There was no reconstitution of managing committee. The private respondents, my lord, are the elected members of the managing committee up to 2022. They are working as on date as the ad hoc managing committee. Payments have been made to them. The issue was that, my lord, in April 2022, for 1 month, the maintenance charge was not paid. Not paid. The check was issued. According to them, it was not paid. Subsequently, it was paid. The entire thing was brought to their notice. They were asked to return the check since the amount has been paid by cash in the next 2 months. It is about 1,500.
Is it a cooperative society? No.
It is a.
How will the writ petition be maintainable?
My lord, I have made, my lord, the register of.
What will the registrar do? You have made the registrar a party, but
Yes.
what is the role of the registrar? What can the
My lord, I
registrar
have made
do?
representations, but since, my lord, there is no managing committee, and, my lord, I have been deprived of the water supply.
Yes.
My lord,
Who is going to look into it? This is a private dispute between the members of the association.
my lord,
Who
my lord,
is-
they are not allowing us, my lord. That is why we have made complaint to the OC, to the SP, but everybody we have made
What?
complaint.
If the police is not acting, then the police determination is different.
Yes, but
What
since, my lord, this is an association, my lord, and since it is registered under the Cooperative Societies Act, my lord.
Under the?
Cooperative Society.
No. It's not a cooperative society.
My lord, we have made complaints to them also, my lord.
To whom?
If your lordship kindly comes to.
What is your submission?
No, but this is Page a 19. private dispute, my lord. It's a private dispute for non-supply
sir,
of the
it went to-
non-supply of the managing committee of the society. The
private
managing committee is not there since 2022. My kindly comes to page 19. My lord, this is an essential supply, my lord. Lift facility I am not getting. I am residing in the
I
third.
understand, but how the writ court can enter into this? This is nothing to do with the government or the state.
Well, if your lordship kindly directs the register, kindly comes to page 19, annexure P2. Well, this is my detailed representation made to the register of firms and
Does
society.
the register of firm
But they
have
have
any authority to look into or decide this issue?
But since the managing committee is not there, my lord, the next step, my lord, I have to approach the register, my lord.
You have to go to the civil court.
Well, if your lordship kindly.
Show me any provision that the register of firms can take up this issue. Come ready. Otherwise, it cannot be maintained. Please come.
Well, if your lordship kindly directs, my lord, the register to consider my representation, my lord, at least.
Show the powers of the registrar under this act. It has only the power to register it. Thereafter, nothing.
But if the managing committee is not there, my lord.
Supervisory function. I don't think so. You show me any provision to allow the learned advocate representing the petitioner to come ready in the matter. List the same. When? Next week?
Next weekend? Yes, madam.
Friday? 31st.
Right.
Service taken on record. Let notice be served upon the non-appearing respondents, intimating the next date of hearing.
Grateful, man.
My lord, in this matter, my lord, the petitioners, they submitted an application for surrogacy, my lord, under the Surrogacy Regulation Act 2021. May I submit the affidavit of
You for
the pro forma respondent,
pro forma respondent?
the surrogate mother.
surrogate mother, your lordship?
Who is for the official respondents?
My lord, I have submitted, I have served them with the copy and also served them with a notice of mentioning as well. The affidavit of service may be.
Are you there?
The state, my lord, Mr. Koshum.
Lordship, I appear for the respondents in this matter, Your Lordship. I have some technical issue, therefore I'm not able to switch on my camera, Your Lordship.
Which respondent?
The Union of India, Your Lordship.
Union of India.
The state is required, my lord. The state is here. I am led by Mr. Kollol Bas. Is coming.
Very well. Let him come.
Please.
Before your lordship's rise, there's a compelling circumstances. Your lordship will price. Give me the leave to move this application, madam.
Move. Why?
My lord, tomorrow is the date fixed where the bank will take the possession.
Yes.
Without notice, nothing of that sort.
The DRT is functioning, isn't it?
My lord, DRT is functioning,
Then?
but the recovery agents,
Ah.
they are roaming around and
So?
the house, my lord.
And the writ court will interfere and the party will not approach the proper forum.
My lord, party
Rush to the tribunal
Rush-
instead
my
of
lord,
rushing here.
tribunal is not functioning. It's not the expeditious remedy. If your lordship kindly
Since the court, since it is functional, since it is moving fast, so you'll come here without going to the proper forum.
kindly consider. I'll satisfy your lordships.
You
Why?
cannot satisfy because the provision of law is otherwise.
My lord, there is there, my lord. I am fully concerned about this. My lord, the circumstances is such, my lord. If we approach the DRT, my lord, it will take at least one
I am aware.
1 week, my lord.
But then
My
work.
lord, in the meantime, my lord, kindly
Interfere.
consider. In the meantime, my lord, kindly consider my prayer. If your lordship so pleases, I'll go back to that tribunal, my lord. Interregnum period, my lord, a relief must be given. My lord, kindly consider. Today in the morning, my lord, client
Supplementary list. Ajke. Keep it. Is it affirmed?
affirmed. Entry has been done, my lord, yet to be affirmed.
कंट्रोल করতে পারিনি হিন্দি শুনে হিন্দি বলে যেরকম হয়
My lord, your kind leave, my lord. My lord, in the morning, I have mentioned this matter, my lord. My learned senior friend is over here, my lord. This matter is item number 20. On 27th, it will appear. There was a direction for compliance of the order. My lord, we have already complied with the matter. If your lordship, my lord, I'm only praying for adjournment for the next week, my lord, and nothing else, my lord. If it can be, my lord, placed on any date after 31st, any date, my lord. My lord,
You are for the petitioner?
Yes, my lord, I am for the petitioner, my lord.
Has the order been complied?
My lord, it has been complied, but question of interest has to be considered in pursuance of your lordship's order.
Next week it can be adjourned?
Yes, my lord. Yes.
Which item?
My lord, this is my item.
Which item?
Item number not in the list. 27, it will come. It's an original side matter, ma'am.
Order to the
Yes.
Is this the time to mention?
Well, I have mentioned in the morning, Mala. It is my
Tell
last.
his learned friend, he'll apprise the court.
Yes, sir.
Nothing now.
My lord.
ওটা ওনাকে দিয়ে দিন। Please remind me on the 27th.
Yes, sir.
My lord, I have a prayer for leave, my lord. This matter relates to the recruitment of assistant headmaster. The matter is very urgent. Earlier, my lord, the notification was issued upon consequent upon the DI order, that is prior permission order. The headmaster started the process, the recruitment process.
Time to mention. And this is not.
My lord, the interview is fixed for tomorrow, and the intern notice, the fresh notice has been issued by the now the present teacher in charge in a surreptitious manner. The petitioner who earlier applied, the petitioner number 1 and 2 earlier applied, now they have been completely excluded from the process, and the interview date is fixed for tomorrow.
Petition and the bench will hear it.
My lord, I have get it affirmed, my lord. Kindly.
It cannot be taken up today. Absolutely no scope. Monday it can appear at best. I cannot.
An urgent motion so that I can serve the notice. That notice will serve.
Monday, urgent motion.
As an urgent motion, my lord. I am grateful to you.
Supplementary আরেকটা আছে
My lord, I am for the petition.
The writ petition has been dismissed. Details of the order will be available in the server immediately.
Grateful, Judge. Grateful.
Yes, we mentioned.
My lord, I had mentioned this, my lord, for correction, my lord.
Yes, Teki. Who is the other side?
My lord, he's here.
I'm for the bank.
Are you aware of the correction that he is making?
Yes, my lord, we had a. My lord, if your lordship just sees paragraph 27.
I am not going to see anything. Only a correction has been sought to be made. Can that be allowed?
The date has to be struck off.
Struck off?
Yes. So it will stop at.
Why?
My lord, because your lordship was quoting.
File আছে?
Relevant portion which lordship had quoted. Lordship will find at 298, page 298. Paragraph 28. Paragraph 28. Last line. Last line, if your lordship sees, can be declared to be a willful defaulter under the relevant master circle of the RBI, full stop. And we have cross-checked, my lord, also on the video. That's exactly what your lordship had dictated in court.
The date was not mentioned.
No, my lord.
If he struck off the date, is there any difficulty?
No problem, my lord, because that is the order, my lord, Justice Bhattacharya's order. I don't have a problem with that also.
The matter has appeared in the list on mentioning by the learned advocate representing the petitioner for correction of the order dated 20th of January 2025. এই ডেটটা কি বলা হয়েছিল? উনি তো বলছেন যে বলা হয়নি। somehow এই ডেটটা চলে এসেছে। আচ্ছা, না পরে আছে, maybe this date is not applicable. This should not have been here. বোঝা গেল? আপনি মাঝে মধ্যে এই জিনিসগুলো ইনক্লুড করে দেন তো, and this is the problem. আচ্ছা, the date mentioned in paragraph 4 of the order dated 20th January 2025 shall stand deleted. ঠিক আছে? So it will end over here. Reserve Bank of India. All right.
Grateful, my lord. Grateful, my lord.
I appear for the petition.
The state respondent.
এই লিস্ট থেকে সরান।
Milord, the petitioner on 13th March 2023, Milord, made an application for grant of permission for surrogacy under the Surrogacy Act, Milord, Regulation Act 2021. Milord, May 2023, Milord, a memorandum was issued directing the petitioners to appear before Milord in the May within a month, 2 months. I appeared. And Milord, 19th May, Milord, the district medical, I appeared and Milord prescription, and they said that verbally advised Milord, my client, to reduce the weight so that she is able to be pregnant. Now, Milord, on 22nd May,
All this.
no, Milord,
What you want.
ultimately, Milord, what happened because of the delay, Milord, which is squarely attributable to the government, that Milord, Milord, crossed the age bar. Milord, 1 month only.
Which one? The husband or the wife?
A wife. Milord, husband is the Milord, the petitioner, number 1. Petitioner number 2.
Cross the age bar.
Husband.
Husband.
Now, Milord, question here is, Milord, 1 month delay. Now, Milord, the appropriate authority, Milord, if I take my Lord's kind attention to the 4 dates. Milord, 19th May, Milord, kindly turns to Milord, page 28.
Yes.
Milord, this is a document, Milord, medical documents, Milord, where the district medical board, all with prescriptions during the said appearance, Milord, it advised me to, Milord, to reduce the weight so that I can undergo, Milord, further medical examination. Page 42, Milord, then kindly comes. Within 3 days, Milord, I appeared before the SS came.
Page 28.
42. Page 28,
28.
Milord, the medical documents.
Legal document.
Then, Milord, then after this document, this was after scrutinization, Milord, the board said, you advise me to reduce the weight so that that is my body weight. Within 3 days, Milord, I appeared before the SSKM, Milord, IPGMR, and a team of, because I was directed to do so, Milord, because it says, Milord, to undergo further medical examination. Page 42, Milord. Milord, the team of doctors, Milord, page 42, Milord, kindly takes pen. Milord, the team of doctors confirmed that petition number 2, Milord, chronic obesity and other medical complications. After more than a year, Milord, 9/5, that is, Milord, page 44. Application having been made, the district medical board issues a certificate of medical indication for intending couple and intending woman, but I was well within the age. 4/6/24, Milord, that is at Milord, I was called to appear before the appropriate authority for obtaining, Milord, eligibility certificate. And Milord, the authority directed the petition number 2 to undergo further examination, and the previous all things, Milord, the IPGM and SSKM ignored. June 24, on successive date across June 24, I appeared and subject to a series of medical tests. I made a specific paragraph, Milord, malevolent in paragraph 12. Then, Milord, 9 July, appropriate authority directed, which is at page 45, to submit pro forma, duly filled up by a fertility clinic, certifying that the intending couple's sperm and oocytes were viable to be utilized for surrogacy. This is a specific averment, page 45, annexure, Milord, paragraph 12. I submitted that. The clinic submitted it, and 16th May, Milord, 16th July, I was called for both the petitioners were called for to Shastra Bhavan and were handed over a document checklist which contained a list of formalities. Page 51. In the midst thereof, Milord, the surrogate mother who had volunteered to bear the child, Milord, suffered certain medical condition, as a specific averment is there, paragraph 14. Milord, therefore, I had to look for another person. I got it. Then, Milord, I again started, Milord, 14/8/24, the formalities towards obtaining life health insurance coverage policies. And, Milord, in the meantime, intervening period, Milord, 9th August, RG tragic incident happens. There was a turmoil, Milord, and for which, Milord, the entire thing, Milord, could not happen. And 22nd August, 14th August, Milord, I started, Milord, when I began formalities towards the obtaining life insurance. 26th August, that is, Milord, page 65, I would cross the age barrier and realizing all formalities for obtaining certificate of essentiality would not be completed before, Milord, the such date. Now, Milord, the question of law, Milord, Milord, my argument, Milord, limb of submission, Milord, the Surrogacy Act, Regulation Act 2021, Milord, holds the fields of, Milord,
Yes.
provision section ta dao 4(3) টা ট্যাবটা খুল না Millard, my understanding of the law, Millard, subject to what my lord say, Millard, a mother, Millard, the desire for Millard, having a child, Millard, it is essentially, Millard, confined to the woman's desire. Kindly cease, Millard, the Surrogacy Act in terms of, sorry, Millard, this is, Millard, the scheme of the act. Millard, may I take, Millard, kind attention to the rule 14, 2022 rule. Millard, Millard 2022 rules, surrogacy regulations rules 2022. Page 60 of the book, page 60. May I take my lord's kind attention to rule 14, Millard? My lord has got it.
Yes.
Millard, rule 14, according to my humble understanding of the situation, Millard, it stipulates that the medical indications necessitating, Millard, gestational surrogacy, Millard, specific reference is drawn, Millard, to rule 14, which includes any illness that makes it impossible for women to carry a pregnancy to viability or pregnancy child is life-threatening. So, Millard, a summative of rule, Millard, 14, Millard, it indicates, Millard, that the condition, Millard, that I was not being able to achieve the motherhood for the medical condition, Millard, which is, Millard, apparent from the record, number one. So, Millard, that is why, Millard, my inability is first, Millard, rule 14. First, Millard, the detection of inability of a mother, Millard, Millard, who wants to have the taste of motherhood, Millard, her inability, Millard, will, Millard, ignite the process of, Millard, the journey towards, Millard, the pregnancy through surrogate mother. If I have correctly understood, Millard, rule
Now,
14.
who has crossed the age bar?
Husband has crossed the age bar 1 month.
What is the age bar
Millard,
mentioned?
age bar 55.
Where is it? Where do I get that?
Section 4, 1, 4, just a minute, 1 minute, dekhe bolo. 4B3, yes.
4(3)(c) Roman 1.
না বিটা পড়া হবে একটু বিটা পড়ে না না এটা বলে বিটা পড়ে না বিটা পড়াতে বলছি একটুখানি
Of the act or the rules?
ও না act section
Yes,
4
section
4 3 Roman 3 CI
Roman 3C 3I
এই জাজমেন্টটা দাও তাড়াতাড়ি জাজমেন্টটা দাও দিল্লি হাইকোর্ট জাজমেন্ট দাও ওটা ছেড়ে দাও ওগুলো এখন সব ছেড়ে দাও
না দাঁড়ান সেকশন
নন্দিনী কুমারটা দাও 2022 টা খুলছে না কেন ওটা
নন্দিনী কুমার কেরালা হাইকোর্ট
হ্যাঁ কেরালাটা দাও হ্যাঁ কেরালাটাকে দাও
What will be your submission?
And
if his lordship take prayer A, my lord, lordship will find the only prayer that has been made by the petitioner is extension of the time to complete the formalities. That is at page 65. Kindly take page 65 once, my lord.
Yes, 65.
The only prayer they have been made because certain checklist has been given to them, my lord, and they have unable to fill up those checklists. So unless and until they have not filled up, then next procedure will not be done. Here, my lord, if his lordship page 65, he's himself said, my lord, that insurance part and other part has not been completed, for which they are seeking time for extension of time, so that, my lord, they can complete the procedure. That is the prayer A, and the page 65 also, my lord.
Millard, your lordship's judgment on IVF, in the IVF matter, Millard, where Millard, the point of law, Millard, which your lordship has decided, Shamoli Shah.
Yes, I have appeared there.
Yes. Yes.
No, that matter is different.
no,
That husband crossed the age limit and certain, that is not with regard to the surrogacy. That is different issue altogether. Now, my lord, here, my lord, they himself, my lord, in page 65, my lord, the criteria has not been fulfilled. That has, for that, my lord, they are seeking time.
Millard, possibly, Millard, may I, Millard, show, Millard, certain judgments pat on the point, Millard, your lordship's court, Millard, and Millard, Delhi and Kerala High Court also, Millard. First of all, the scheme of the act. my lord, the inability on the part of a male, my lord, in respect of the surrogacy, where he has no, my lord, actually, my lord, first of all, the court had interpreted this provision, my lord, that the 129th parliamentary report, when this law was, my lord, enacted, before that, my lord, there was a discussion. With regard to the age bar, my lord, the Kerala High Court had made certain observation. The parliament was, my lord, conspicuously silent with regard to the age bar of a male, my lord, in respect of surrogacy. Now, my lord, the Kerala High Court and Delhi High Court, I will show, my lord, only 4 judgments.
What is the prayer that you will be seeking today?
Today, my lord, the 1 month during, my lord, 14th August, my lord, I crossed age bar 1 month. 26th August. My lord, I was, my lord, because a huge amount of LIC, my lord, which I have to do, my lord, I obtained the checklist. Everything is now complete. It is not that the process is not complete. Process is complete.
Has anybody stopped you from proceeding
No,
with?
the law creates an impediment since I have crossed 1 month during the, my lord, checklist. That is, now, my lord, my respectful submission, 13th March 2023, when the application was made, government took, my lord, 1 year, 5 months, my lord, to process the entire thing. My lord, I said, my lord, on 19th March, when I attended, I was sent to, my lord, SSKM IPGMR. Then, my lord, in July 2024, my lord, when I was again sent to, my lord, SSKM IPGR, the same institute, my lord, did not take into an account its earlier board's recommendation, which, my lord, declared, and, my lord, and the government discarded it. Question is, my lord, IPGR and state SSKM hospital, my lord, one of the premier, my lord, institutions of the state. Now, what was the occasion for the government not to take note of, my lord, the earlier one, the May 22, 2023? My lord, it is not known to anybody under the sun. Now, under this, on this core, my lord, the question is, my lord, what is the scheme of the act? If the scheme of the act, my lord, essentially, my lord, concentrates on the right of a womanhood, my lord.
1 minute. Who will be the appropriate authority to take a decision in the matter? The principal secretary or the Kolkata District Medical Board?
They already given certificate, my lord. I have referred this, my lord. That is, my lord, the certificate of
Will be the appropriate authority. Will give me the certificate of essentiality.
essentiality certificate will be state 4.
Page certificate.
Page 3, my lord, of the cost title, my lord. I have said state appropriate authority constituted on the
No, where
surrogacy.
is the certificate?
Certificate of the district board.
Certificate
না না মে 2024 কোথায় গেল না আগে এই তো
Page
না এমলেট 44
Page 44, Lordship.
44,
Lordship.
certificate of medical indication. This is 9th May 2024.
my application was in, my lord, March 2023.
Yes.
So, my lord,
There was a delay.
delay 23
Hmm.
23 to 24 May, 1 year 2 months. And then, my lord, August 2024, 26th August, when I crossed 1 month, because of this formality, but I have done each and every formalities within the period.
My lord, I think, my lord, in
Question is, my lord,
page 27, my lord, hearing was called in 23. 19/5/2023.
my lord, I with deepest respect to my learned, yes, I have said so. I have said so, my lord, with deepest respect to my learned friend, my lord. My lord, I have mentioned this in the second limb of my submission, that it was done. Serially chronological narrative is there. So, my lord, question here is, my lord, my right. My lord, first of all, a woman's desire, my lord, under this act to have the test of motherhood, my lord, will not prejudice the, my lord, state's interest. It is not against an imperial interest.
It is not the state's interest.
Correct.
The age of the
Age
couple
of the couple, my lord, I tell your lordship,
important.
when in an age, the parliament was silent with regard to the only 1 month, and when the parliament is silent, my lord, I will also show I am armed with the, my lord, kindly visualize the situation when, my lord, in an age where the existence of the husband, my lord, hardly matters, because today in an age, my lord, the court recognized the existence and dignity of a single mother also. It hardly matters, my lord.
Right,
No, so today, my lord, today is a day when the existence of a husband, my lord, even in the act, my lord, the parliament was, my lord, consciously silent on this issue.
So for this age is
It is my right. It is my body.
by the Union of India.
It is my right. It is my right.
No. His submission is, had the certificate been issued in proper time,
Lordship.
then the petitioners could have proceeded.
Might not have crossed that.
Mr.
My lord,
Bose,
sorry, I'm sorry.
I'm thinking of relegating the matter to the principal secretary to take a decision as to whether they can condone it or something. The court is directly not passing any order because as on date, they have not
My lord has passed order in IVF matter, my lord.
in the IBF matter,
Yes,
but
my lord.
in the
Now,
surrogacy matter.
age bar is same. Question is, my lord, whether it affects the motherhood. My lord, I take your lordships kindly. My lord, kindly decides this issue, my lord.
Then it has to be heard.
No, my lord, hard, my lord, by this time, my lord, that the time flies, my lord.
Yes, this is the reason I want
No,
to send it
because
to
if your
and
lordship,
I'll
my lord,
refer
if your
this also.
no, my lord, if your lordship sends it back, because all records are before your lordships, either I am entitled under the law, and question is, my lord, whether the state can take privilege of its own wrong by, my lord, commissioning the delay. Number one. Number two, my lord, my right, it is my body. Suppose I disown my husband, my lord, tomorrow.
Wait one. Can you take instruction from the principal secretary?
Yes.
And this judgment which has been passed in the ICF
I
matter.
will give him the catalog of judgments which I want to rely upon.
Catalog.
Not catalog. Only Odorkani Samolisa and the late position. That না অসুবিধা আছে তুমি চুপ করো তুমি I shall I.
Okay. Come up with written instruction. You will leave. Yes, yes.
যাও যাও পড়ে যাবে
The petitioners intend to avail the benefit under the surrogacy within bracket regulation bracket close act 2021. Stop. The hurdle to be crossed by the petitioners is that the petitioner number 1 has crossed the maximum age limit of 55 years only a month back. Stop. The delay was caused in obtaining the certificate of medical indication for intending couple. On account of the procedural, on account of the time taken for meeting up the procedures, and though the initial application was made by the petitioners in May 2023,
March 20.
Page 27, I see it's May.
My lord, that was the notice of hearing before.
Notice of hearing. All right.
The application is at page 23, my lord.
Right. On 23rd of March 2023, the certificate was issued. Certifying the couple, certifying the reports of the intending couple to be in order only on 9th May 2024. Stop paragraph. It has been submitted that had the said certificate been issued in proper time, the petitioners would have been well within the prescribed age limit for availing the said benefit. Paragraph. Reliance has been placed on the, show me the order please, the judgment delivered by this bench. Relies upon the judgment delivered by this bench
776
on 22nd November 2024 in WPA 23776 of 2024 within bracket Shamuli Shaha and another Bananta Dekaneben versus State of West Bengal and others, wherein the court permitted the couple to avail the benefit under the assisted reproductive technology within bracket regulation bracket close, Act, 2021. ঠিক আছে? Stop, next. Any further delay in deciding the instant writ petition will add up to the delay on the benefit that may come to the aid of the petitioners. Stop. Paragraph. In view of the above, the court requires a written instruction from the Principal Secretary, Department of Health and Family Welfare regarding its stand. Stop. The Principal Secretary shall take into consideration the observations and the direction passed by the court in the matter of Shamoli Shaha within brackets Supra. List the matter on 12th of February.
My lord, before parting, my lord, just one submission, one brief submission. Previously, a single bench of the Honorable Single Bench of this court has condoned the delay in case of Surrogacy Act. And there was another
judgment. Give, I'll refer it.
My lord, right now I don't have the copy.
Give the citation, date, put it down in a piece of paper and hand it over so that I can include it in the order.
All right. The only thing, my lord, I must indicate is that it went up in appeal. And the Honorable Single Bench had also said, as part of his lordship's judgment, that this provision of age barrier is directory. Now, the appellate bench has stayed that portion of the judgment whereby it has been made merely directory, because the Honorable Appellate Court said it appears to be a mandatory condition. But only those observations were stayed. But as regards granting them permission to go forward with the surrogacy, that has not been stopped in the appellate court, by the appellate court.
Let me come back.
I'm not including that.
Yes,
I'm just keeping it
I'm
silent.
indicating, my lord. Grateful, my lord.
Yes, 21.
I am appearing for them.
Who is your other side?
Mr. Lolit Mahato, I have informed regarding upgradation also.
Is he here or he has left? He said he won't be here. What do you want to file? Service? Please give. Where is his junior?
This matter pertains to the selling of a land of tribal. The petitioner before your lordship is the scheduled tribe man. Aged about 57 years. Some doctoral advice regarding he is suffering from some diseases. Wants to money.
I understand, but
now
without
14C.
State.
Intimation has been given to the BLLR for selling the land to non-scheduled tribe candidate as per law. The BLLR or the other authorities keeping ties of the matter.
All right. Which is your prayer?
Yes, representation at page 29 onwards.
29, please come.
Let them
Which
take
one,
a decision.
Which one you like to be considered?
P6 31.
Very well.
And copy also made to over to the all these authorities page 32.
He's a tribal and he holds certain land in his name.
Yes, deed is there, my lord.
Very well.
I have annexed the deed itself. Page 21 onwards.
Due to some medical emergency, he requires immediate financial support. Stop. He intends to sell off the said land.
But one thing, I have made communication over the publicly published in the page Bottoman paper itself also. Everything has been done. Panchayat authority also given certificate to page 27.
Stop.
NOC.
Steps taken by the petitioner to obtain a buyer from the tribal community for purchase of the land has turned out to be futile. Stop. Newspaper publication has also not helped the petitioner. Stop. Paragraph. The petitioner made a representation before the
all the authorities, page 30 and 32. Respondent number 4 is the revenue officer as per law is the authority as per 14C.
Before the respondent authorities
Respondent
seeking permission
4.
to permit the petitioner to sell off the land to a non-tribal. Stop. The representation is pending consideration. Stop. None represents the respondents. Service.
Yes, affidavit of service is there.
Service taken on record. Paragraph.
As well as the upgraded notice also.
আচ্ছা আপগ্রেডেশন নোটিশটাকেও রেখে দেবেন আচ্ছা as the petitioner is in need of immediate financial assistance, the court intends to dispose of the writ petition by passing the following direction. Stop. Paragraph. The respondent number 4, being the additional district magistrate and the district land and land reforms officer, North 24 Parganas, is directed to consider the prayer of the petitioner to permit him to sell off his land to a non-tribal. Stop. Steps shall be taken in the matter in accordance with law at the earliest, but positively within a period of 8 weeks from the date of communication of this order. A reasoned order shall be passed and communicated to the petitioner. Paragraph. The learned advocate for the petitioner is directed to forward the representation made before the aforesaid authority along with all other supporting documents at the time of communicating the order of the court. Disposed.
Much obliged, Your Lordship. Grateful. Is it required? 14C column number 3 is required to be? No. Grateful. Much obliged.
I appear for the petitioner. So may I file the affidavit of service and the notice, 2 affidavits for service and for upgradation. Lordship, the order of the dispute resolution committee is under challenge. This is the second round of litigation.
Order of the
Dispute resolution committee. A tender was granted in favor of the petitioner because of various reasons not attributable to the petitioner. Ultimately, he could not complete the work within time and it was terminated. Challenging the order of termination, I filed a writ petition, and subsequent allotment, it was allotted to somebody else. So I'm not challenging the subsequent allotment of work order. So for work which I have done, according to my estimation, that payment has not been made. It was referred to the dispute resolution committee. Initially filed a writ petition challenging the termination order. Since there was in the contract, there is an inbuilt provision for referring the matter to a particular redressal committee, the Honorable Court recording certain observations which are required to be followed at the time of termination of the contract. The coordinate bench recorded and ultimately referred the matter to the dispute resolution committee. That order was upheld by the division bench. Lordship, kindly come to the order of the earlier order passed at page 88. It starts from page 88. The relevant provision which I am relying upon is at page 90. The clauses of the tenders are mentioned there in clause 27, 52, plus I am relying on 53. Clause 53, however, cards an obligation on the engineer, that is the employer, to issue a certificate for the value of the work done, less liquidated damages in the event of contract is terminated because of fundamental breach by the contractor. My tender was terminated on the allegation of breach of fundamental breach of contract. Now, Lordship, accordingly, it was referred to the dispute redressal committee. I have preferred my appeal before the dispute redressal committee, and after giving opportunity of hearing, the committee ultimately passed its order, which is at page 140. It starts from page 140, and the recordings, it is the communication. Basically, the order is at page 141. Lordship, I am just the last paragraph at the bottom. After considering all the facts, circumstances, and document, the committee resolved as follows. Notice to proceed with the work was issued on such and such by the executive engineer. As per NIT, completion time was 9 months, excluding rainy season. COVID-19 pandemic situation came with effect from so and so. Formal written prayer for extension of time was submitted by the agency, that is the petitioner, initially on the occasion of ongoing COVID-19 pandemic lockdown, during the period on different phases, and thereafter on the ground of sudden illness of the key person of the agency, Mr. So and so. Though formal written sanction letter for time extension was not issued, that is the observation of the committee, initially in consideration of all aspects, but the time of completion was finally and formally extended up to 30th June 2022 without any mention of liquidated damages. It was recorded by the committee. Therefore, the termination was illegal. Kindly come to the paragraph where the committee recommended at serial number 3 at page 142. The agency claimed for removal of its name from the list of blacklisted agencies in the record of so and so. The committee recommends for removal of the agency's name from the list of blacklisted agencies under so and so if already done by this time. The committee ultimately came to the conclusion that my termination was not made in terms of the contract, yet they did not declare the termination as illegal. Although they recommended, had my was any fault on my part, they would not have recommended for removal of my name from the blacklist candidate. That was recommended. My security deposit that was held by the agency engineer, that was directed to be refunded. But the work done that was not computed by the engineer, that was not paid, and unless my termination declared to be illegal, I cannot claim compensation because they have awarded the work at a much higher rate to the subsequent bidders.
So your prayer is for removal
That
for
prayer was allowed from
for
blacklisted candidate, refund of,
setting aside the termination order?
or to declare the termination as illegal. Because the committee, they recommended that it was not the liquidated damage that was not followed.
Liquidated damage is different.
Because that is the prime consideration for declaring a termination of contract as illegal on the ground of fundamental breach. This was recorded by this honorable court. Ultimately, when it was referred to the committee also came to the same conclusion, but they did not declare the termination as illegal.
Mr. Sen, can this be decided without affidavits? I don't think.
Well, first thing, Lordship, may I tell?
Hmm.
First thing is that, my lord, kindly come to the, my lord, the order of the Honorable Division Bench. My lord, that is at page. Na, chup koro. Na jene. Ulto palta poko na. 90.
Division Bench
95.
93. Starts from 93. Division Bench order.
95. It starts from 94, 93, but my lord, kindly have come to, my lord, 95. My lord, first of all, my lord, the order of the division bench merged with the order of the single judge merged with the order of the division bench. The petitioner preferred the appeal, intra-court appeal, and the division bench passed this order. Now, my lord, kindly come to, my lord, paragraph number 7. Eventually, we find no ground to interfere with the order passed by the learned single bench in the event the appellant invokes clause 24 of the terms and conditions of contract by availing the dispute redressal system. The competent authority in terms of the said clause shall expeditiously consider the prayer made by the appellant and conclude the proceedings as expeditiously as possible, preferably within a period of 3 months, in terms of clause 24 of the terms and conditions of contract. Everything open, matter referred to that redressal committee. Now, redressal committee, my lord, after taking note of all the, my lord, the submissions made by the parties, and my lord, then came to conclusion this. So this is the order of the redressal committee. Now, in case any, my lord, grievance against the order of the redressal committee, then what step he may take, the forum. Now, lord, she kindly come to page 47. That is, my lord, the part of that, my lord, the tender document, that is the contract. This is the general conditions of contract. Now, page 47. Have you got it, my lord? Page 47. The 24 is the caption dispute redressal system. Now 24.1 is that if any dispute or difference of any kind of whatsoever shall arise in connection with or arising out of this contract or the execution of works or maintenance of the works thereunder, where before its commencement or during the progress of works or after the termination, even after the termination, abandonment, wide scope like arbitration, wide scope, breach of the contract, it shall in the first instance be referred for settlement to the competent authority within 45 days. That is the dispute redressal system. Now they, my lord, choose this forum. Then lordship for 24.2, either party will have the right of appeal against the decision of the competent authority to the standing empowered committee within 90 days of decision of the competent authority if the amount appealed against exceeds 0.2% of the initial contract price. Here, my lord, the grievance is that after third RA bill, running account bill, after third RA bill, nothing paid. This is one of the grievance. And the other grievance is that the termination of contract and other thing. So these 24.2, now, my lord, he has to invoke. So far, my lord, this, because once you choose the forum, 24.1, then you have to choose the other forum that is the left open, my lord, for you, for your another grievance or subsequent grievance arising out of that 24.1. Now, my lord, another thing is that now there is a judgment of 2021 10 Supreme Court cases. Now, if your lordship kindly have a look that how and to what extent the writ court can enter into in case of road construction matter. It was specifically, my lord, it was also a lot arising out of road construction matter, tender issued according to the claim that our payment has not been made. Now, lordship, kindly come only 3 paragraph, paragraph 2, 3, and paragraph number 24. Yes, 2021 in SCC, page 690. Now, paragraph 2, the learned single bench of the High Court allowed the writ petition filed by the respondent who had sought quashing of letters dated such and such with interest. And then, lordship, kindly come to 3. The learned single judge held that payment in terms of final joint survey / measurement report dated 24th of October 2013 be taken into consideration for making revised detailed project report, and thus pass necessary orders for payment of amount due to the writ petitioner within 4 months of the receipt of copy of the order. In an appeal filed by the appellants, the division bench of the High Court held that resurvey for measurement and DPR would not be just and fair at this stage since 5 monsoons had passed. Therefore, the only option left to the appellants was to approve the DPR and pay the pending bill on the basis of final joint survey or measurement report dated 24th October 2013. And now, lordship, kindly come to paragraph number 24. At page 705. Therefore, the dispute could not be raised by way of writ petition on the disputed question of fact. Here is the disputed question of fact all along, that after third RA bill, you did nothing. You said that the COVID and other thing, then you fell serious ill, but it was a public interest matter. We could not wait. And so up to that stage, RA bill passed. But after that, since you did not work, so no question of any further payment. This was the contention of the, my lord, the respondent authority. Though the jurisdiction of the High Court is wide, but in respect of pure contractual matters in the field of private law, having no statutory flavor, are better adjudicated upon by the forum agreed to by the parties. The dispute as to whether the amount is payable or not, or how much amount is payable, are disputed questions of facts. There is no admission on the part of the appellants to infer that the amount stands crystallized. Therefore, in the absence of any acceptance of joint survey report by the competent authority, no right would accrue to the writ petitioner only because the measurements cannot be undertaken after passage of time. Maybe that the resurvey cannot take place, but the measurement books of the work executed from time to time would form a reasonable basis for assessing the amount. But such process could be undertaken only by the agreed forum. Now, so, my humble submission is this. At this stage, my lord, after my lord choosing to my lord submit before the authority in terms of 24.1,
Very
then
well.
the left open 24.
I got it. Tell me,
24.2, if you look page 47,
24.2.
it says the where the amount is involved. Here, nothing was declared. Enter, Lordship, the prayer of my is at page 138 of the petition.
Not only the amount, after the termination can also be an issue over there.
Everything.
Now, when this committee, they came to the conclusion that it was
Yes, you go
terminated
before the appellate
without
court.
following the.
Please come. The petitioner is aggrieved by the reasoned order passed by the Dispute Redressal Committee on 4th of July 2024. Stop paragraph. Learned counsel representing the state respondents refers to clause 24.2 of the general conditions of contract, which is the part of the contract, and submits that there is a provision for appeal against the decision of the competent authority to the Standing Empowered Committee, SEC CAPS.
Earlier, it's a dispute redressal committee as per 24.1.
ঠিক আছে? As it appears that the petitioner has already availed the remedy before the Dispute Redressal Committee, in that case, being aggrieved by the order passed by the Dispute Redressal Committee, the appellate forum will be the Standing Empowered Committee. Stop. It will be open for the petitioner to raise all issues before the said appellate forum. Stop. In the event an appeal is made, the same shall be considered by the forum, by the appellate committee, in accordance with law. Take this back. I don't require service. Next one is also same.
It is with regard to a separate tender.
Date of the
No, dates are different. Lordship, I will just indicate the date. The date 2nd September. Earlier it was 4th July 2024.
2nd September 24.
It was 2nd September 2024.
Very well, same order. Are you there? Record his appearance.
Yes. Yes.
This is my application, Miller. Petitioner, Miller. So this is matter against the CSC, Miller, where the CSC has disconnected my.
I am for CSC. My senior Dr. Madhusudan Sahara is out of station till 28th January, for his brother-in-law's marriage ceremony.
Without electricity, my lord. But they have disconnected my electricity on the ground that I was providing electricity to a flat which belonged to a defaulter. But the fact remains that flat belongs to me. I am the one who is enjoying the electricity. There was a due in respect of that.
If you have electricity in one flat and you cannot pass it on to the other flat.
No, there is only one flat which is in my name. I purchased that flat in the year 2018. They come up with fine day.
Show me the notice of disconnection.
My lord, one fine day they come up with a notice that.
Notice of disconnection.
My lord, page 39, my lord. This notice was served on me after disconnection.
5th of November 24.
My lord.
Yes, then. And disconnection made?
My lord, disconnection was made, my lord, on this on the same date, my lord.
5th November
5th November at 2:30, my lord.
Right.
Now, when they came, they said that there is a due in respect of this electricity. but there was no due. We find that they come up with this new story that we are providing electricity to another flat, but the fact remains that that flat belongs to me. I am the flat owner. 2018, my lord.
Well, very well. From November, you can wait. You can wait for 1 more week also. Please come. Accommodation has sought for.
Kindly fix the time after 28 January.
On behalf of the Learned Council representing CESC Limited. List on 29th.
The 29th, my lord.
Yes.
And another item 29.
No.
Well, 25, this is my application, my lord. Now, these are two affidavit of services. Oh, in upgradation and notice that. My lord, the
মধুসূদনের নাম তো নেই, ও কি করে ওর নাম হবে? যে Yes.
my lord, the petitioner is a ailing person, my lord, has participated in a lottery of a house conducted by the housing board for obtaining a flat. My lord, the rules of that my lord, lottery suggested that after the lottery was made, you cannot choose to opt for a fresh or a different flat. My lord, the petitioner has applied since she was ailing person. She is staying as in a rented accommodation in the first floor of that very flat. My lord, she has sought to have that flat. My lord, I have
regularized in her
regularized, but it was not done. Thereafter, lottery was held. In place of there were 21 flats. Only 2 persons came up to participate in the lottery, and 19 is still pending. Page 27 is the result of the lottery, in which the petitioner was allotted a flat in the 4th floor. The petitioner resides in the 1st floor as in the rented accommodation. My lord, before this lottery was made, my lord, the petitioner, the page prior to that, page 26, my lord, have this flat to be, my lord, changed to the flat which I am residing at. That is the whole pith and substance of my writ petition, because there is 19 flats which is still lying vacant, including the flat that I am staying on rent.
That has not been allotted to anybody.
No.
Where
And
is your prayer before the board?
my lord, the prayer is at, my lord, page 15. Page 14, it starts, prayer C. And there is an order of rejection to that effect, my lord, last annexure.
Where is it?
Last annexure, it's, no, I stand corrected, my lord, is at page 29, P6. The order of rejection says about clause 22 and clause 30 of the housing board manual, which I have appended at page 40 and 43.
Is the flat of the same nature?
Yes, absolutely, same and identical. And the rejection order refers to 2 clauses, that is clause 22, which is at page 40, which suggests no prayer for change of allotted unit shall change of floor CPC location shall be entertained after the lottery is completed. My prayer was made before the lottery. Lottery was held in the month of August. My prayer for having the existing flat in my name was in the month of May, soon after I participated in the process. But the participation is at page 24. My application is at page 26. th of May, and the lottery took place in the month of August. And with regard to Rule 30 also, it suggests that I have to ascertain my right of a proposed flat. Rule 30 is at page 43. And the note of Rule 30. Which suggests that, my lord, before the application, I need to certify and I need to check clearly which flat I would intend to take. But it was no opportunity was given to me. If had the opportunity been given, I would have chose that particular flat which I am staying on rent. So the question of having these two clauses as an embargo of having this particular flat probably does not arise in my case, my lord. And I am an ailing person. I have came to Durgapur to have my regular medical checkups done. No, I'm staying nearby. Hence, it's Durgapur. Thereafter, also, I had made after the lottery was made, I reiterated my prayer that since I had already made my prayer previously, kindly considers that. But such was not considered, and this order was passed.
Yes, authority.
But housing board is the authority, my lord.
Oh, you are not representing the board?
No, my lord.
Page 24 is your application, 22nd of March.
Page 24, upon the payment of
When did the lottery take place?
lottery took place, my lord, it's at page 27, 27th of August, 2024. It is not that I was thrown out, I was allotted, but on the 4th floor of that particular building itself.
Who appears for the board?
No, previously, Mr. Bihani used to appear. No, Bihani. I don't know whether now he's still appearing or not.
May I then check up and serve a fresh notice on him and keep it kindly keeps it on Monday so that
By Monday you cannot do it. I'll keep it on Wednesday. You serve. Please come. The petitioner seeks regularization of flat number
page 15.
B22/06 or 16?
6.
06. Stop. She participated in the lottery but was selected for a different flat. Stop. Paragraph. She submits that she is an ailing senior citizen and
Not ailing senior citizen, her age is 59.
she is ailing.
Ailing.
She is suffering from various illnesses and she has been advised by the doctor not to climb up the stairs. Does these flats have any lift?
For that, I need to take instructions. I do not.
All right.
That has not been pleaded, my lord.
No, I do not have that instructions.
Because only because you are there in one floor doesn't mean that you cannot go up. If the lift is there,
I am just, my prayer is with regard to the 19 have already are vacant, including the flat which I am staying.
Whatever. Acha. Her prayer stood rejected as the same violates the GTC. What is this?
GTC is
22 and
General Terms and Conditions, page 29, rejection order.
Of the general terms and conditions.
Page 30, my lord.
Of the West Bengal Housing Board. Stop. Paragraph. None represents the board. Let a further notice be served. List on 29th. Stop. Learned advocate for the board shall take positive instruction as to whether the prayer of the petitioner for regularization of the flat which she is holding as a tenant can be allowed or not.
Grateful, madam.
Hmm.
Lord, I am for the petition.
And I am for the respondents.
Which respondents?
And I am for the railways. Railways, Lordship.
My Lord, 1st November 2023. Now, my Lord, railway authorities, here the dictator, they have floated an intended notice. My Lord, purpose is, my Lord, for the purpose of parking lot at the Sealdah railway station. Now, my Lord, contract was for 3 years. Now, my Lord, agreement amount was 27 crores and all, 50 lakhs and all. And annual license fee was rupees 2 crores and all. And area is 2000 square meter. Now, my Lord, petitioner participated in that said tender, elected by the railway authorities. Petitioner deposited the earnest money deposit to the tune of rupees 10 lakhs and odd.
62 lakhs.
And also, my Lord, 52 lakhs and odd as per the agreement. Now, my Lord, ultimately, my Lord, railway authority handed over the possession of the said parking lot to the petitioner. And petitioner started to collect the parking charges. Now, my Lord, they handed over it on 23rd November 2023. Now, my Lord, page 44 and 48. Now, my Lord, on 6th December 2023, railway authorities blocked part of the portion. Out of, my Lord, 2000 square meter, they have blocked part of the portion.
What has happened? Further auction?
Now, what has happened in this case, my Lord? Previously, I moved a writ application before this honorable court where they have cancelled the agreement. Now, my Lord, you will have to kindly come, my Lord, page 60, relevant page 62. Page 62.
Thereafter, an opportunity of hearing was given to you and the parking lot was directed to be handed over subject to payment of some money.
Yes. Now, my Lord, ultimately they have cancelled. They have cancelled. Then, my Lord, I paid to pay the suffered which I have lost for the my Lord,
Partial blockage.
Partial blocking of the place. Now, my Lord, they have calculated it. This is a case of, my Lord, practically in this case, at the present moment, I can't pray for any interim order, only affidavit should be, my Lord. Now they have, my Lord, your Lordship kindly see, they have waived, my Lord, only 4 lakhs. And my claim was rupees 21 lakhs and odd, which I have suffered. And that is, my Lord, if your Lordship kindly see, my Lord, page 71 and 72. May I read, my Lord, page 71, last part, proportionate relief, waiver of license fee has been calculated by rupees 4 lakhs 32,787 and 37 has been calculated and approved by the competent authority. The license due to conduct the development work by the railway at the mixed parking lot at the Sealdah railway station with partial block from 6/12/23 to 14 January 24, my Lord. Though they have assured that within 10 days they will hand over from 6 December 23.
But 40 days.
Now 40 days, my Lord, they are blocked, as a result of which, my Lord, I have suffered a tremendous financial loss. And I claim that amount, that this is the loss I have suffered. Now,
The extension of time.
and or further extension of time to pay the second installment. Now that was, my Lord, turned down, and not only that, they have already
Further auction has been taken place.
auction has,
What remains?
my Lord,
What remains now? Compensation?
yes, my Lord.
Go before the competent forum. Why here?
My Lord, I have,
There is an appellate authority.
my Lord, I am fortified by a judgment of the Supreme Court. May I explain that?
Five, 557. এখানটা
Here, my lord, Supreme Court, this is a money claim, my lord. Here also there is a money claim. And writ application was filed. Now, my lord, trial court held that writ is not maintainable. You should prefer a money suit.
This is not a money claim. This is a compensation that you are seeking.
The compensation. My lord, dear lordship,
And right now there is an.
it's practically enforcement of contractual obligation.
So that is more so the reason you should approach the competent forum.
My lord, this was held by the Supreme Court.
Here is an order of the divisional commercial manager. Who is the appellate authority?
Page clause 16, Lordship, page 30.
Page 30.
Appeal against punitive action of EMD SD forfeiture termination of contract on any grounds.
Page 30.
Has the Lordship got it, my lord?
Yes, DRM, he has approached the DRM. DRM has already passed order. Who is the appellate authority?
Appellate authority also passed them.
After stipulated time.
DRM order is also there.
That order was also passed, my lord.
After stipulated time.
Right now, there is no other forum apart from the civil court.
Yes.
Please come. The petitioner is aggrieved by the order passed by the Divisional Commercial Manager, Eastern Railway, Shialda, dated 23rd October 2024.
ওটা হচ্ছে একটু কন্টেম্পটের ব্যাপার ওটার সাথে তো ওটা রিপোর্টের ব্যাপার
Stop.
ওটা তো ভায়োলেশন
It appears that the dispute arises out of a contract entered in between the parties. Stop. Paragraph. The petitioner is aggrieved by the termination and seeks compensation. Paragraph. I am of the opinion that the issue cannot be decided by the writ court. Stop. Paragraph. There are questions of facts to be adjudicated for providing adequate relief to the petitioner. Stop. The same cannot be done in a writ proceeding. Stop. Next. In view of the above, the instant writ petition is disposed of by observing that it will be open for the petitioner to approach the competent civil court for redressal of his grievances if so advised.
My lord, you will also refer the matter to
The civil court.
the civil court. My lord, then my lord, kindly see this judgment, my lord.
Give.
Termination না করে যে বন্দোবস্ত করে দিচ্ছি
My lord, this is 2004, volume 3 SCC, my lord. 553. 553. My lord.
Which paragraph?
Which
My lord, para 16.
ABL.
Aye.
No. It's a very celebrated judgment.
My lord, here my lord, Supreme Court held, my lord, that it will take much time before the civil court.
Yes, but then
There is any dispute.
Yes.
It should be decided by giving an opportunity to the respondent for filing affidavit, my lord.
No.
Right, take it down. Right.
Yes.
Well, I've got an assignment.
My lord, paragraph 16, my lord.
Yes, I'm aware of it. 27, you've got an assigned matter.
41.
Hmm.
I've got a train at 4 p.m. If you logically take the matter today, I can.
4 p.m. train, it's 3:30. How can it be taken up?
I don't know.
You can leave. You can leave. It will be there in the list. All right.
Oh, it is at 4:35. Yes, 435.
But then you cannot finish up the matter within so short time.
Then fix it on 28.
28
Anytime.
is a
Fix a
Tuesday.
time. 28.
28 is a Tuesday.
Then 29th.
Tell your junior to follow the list. Assign matters.
After 27 months, any day.
জামাইবাবু 40-41টাকে একটু ওপর দিকে দিয়ে দেবেন তো, এইটাকে 3টে 15 4টে 15 32টাকে পরে দিয়ে দেবেন, এটাকে আগে তুলে দেবেন, তাহলে এটা শেষ হয়ে গেলে আমরা এটাকে ধরতে পারবো। না, আমি হেডিং তুলতে বলি। Yes.
My lord, in item number 27, my lord.
I have directed that your matter will appear under the heading assign matters at the top.
On
It will be there in the list.
on Friday, after 27, on 28 or 20, any day, after 27.
আমাদের অ্যাসাইন ম্যাটার কি রোজ নেওয়া হয়? কবে নেওয়া হয়? Tell your junior to mention, I'll take care.
Get Procedural.
My lord, in item number 27.
For the petitioner in this matter.
My lord,
I
in item
have
number
some
27.
urgency.
He has got some urgency. If it can stands for the day, my lord, only for I am today indisposed, little bit.
Maybe I'm placing.
Indisposed.
Only for the day.
That's only one word, indisposed, learned cows.
Only for the day, my lord.
One day. Come back. It will be there in the list. Under which heading it is there?
Let it be the top.
Let it be on the
urgent position.
Urgent motion.
Urgent motion দিয়ে দেবেন তো?
Upgrade গুলো নিচ্ছেন না my lord রোজ। Urgent motion.
Urgent motion.
Grateful. Affidavit of service থাকুক।
Take instruction.
My lord. That's why also.
As সার্ভিসটা ফেরত দিয়ে দিন, otherwise I have to record an order.
Let there be.
Let there be an order. Do one thing.
Order.
জানাবাবু রাখুন, লিখুন তো affidavit of service filed in court is taken on record. Stop. On the prayer of the learned advocate representing the respondents.
No, bank. Respondent bank.
Achha, respondent
I'm
bank.
of the state respondent.
All right, bank. The matter stands adjourned for the day. List on 27th as urgent motion.
Much obliged. Get. প্রদীপ নামটা দিয়ে দিস।
The passport will expire on 29th March 2025. March. Now, my lord, 11/9/2024, my lord, I applied for renewal. Now, my lord, it has been informed that, my lord, that there is a criminal case, my lord, FIR registered in the month of, my lord, September 2023. Gorihat PS case, 415, 420. Assuming the very serious allegation, but I have also filed, my lord, the criminal revision application before the Honorable High Court for quashing of the FIR. Now, my lord, what is the nature of allegation, my lord, that has been enumerated, my lord, in paragraph 5?
What is the
today-
status of your application seeking renewal?
Now,
Has
my
it
lord,
been
I have
allowed?
made a representation that 29th March is the date, but my lord, no response.
No, but then you have to obtain a no objection from the criminal court where the matter is pending.
Now, my lord,
and then
today,
you apply.
my lord, I only one judgment, 6 lines, 7 lines, my lord. 2021 SCC online, page 3549, only 7 pages.
Read out.
My lord, first it records, my lord, that what is section 6.2 the Passport Act 1967. Subject to the other provisions of this act, the passport authority shall refuse to issue a passport or travel document for visiting any foreign country under clause 6C of subsection 2 of section 5 on any one or more of the following grounds, and on no other ground, namely that the applicant is not a citizen of India, that the applicant may or is likely to engage outside India in activities prejudicial to the sovereignty and integrity of India, that the departure of the applicant from India may or is likely to be detrimental to the security of India, that the presence of the applicant outside the India may or is likely to prejudice the friendly relations of India with any foreign country, that the applicant has at any time during the period of 5 years immediately preceding the date of his application been convicted by a court of India for any offence involving moral turpitude and sentenced in respect of thereof for the imprisonment for less than 2 years, for not less than 2 years, that proceeding in respect of an offence alleged to have been committed by the applicant are pending before a criminal court in India, that a warrant or summons for the appearance or a warrant or the arrest or the applicant has been issued by a court under any law for the time being in the force, or that an order prohibiting the departure from India of the applicant has been made by any such court, that the applicant has been repatriated and has not reimbursed the expenditure incurred in connection with such repatriation, that in the opinion of the central government, the issue of the passport of travel document of the applicant will not be in public interest. The refusal of a passport can only be made in case where an applicant is convicted during the period of 5 years, immediately preceding the date of the application for an offence involving moral turpitude and sentence for the imprisonment for not less than 2 years. Section 6.2 relates to a situation where the applicant is facing trial in a criminal court.
What is the ratio laid down here?
Admittedly, here, Miller, the conviction was made for 1 year. Even then, the Supreme Court said, at present, the conviction of the appellant stands still at the disposal of the criminal appeal. The sentence which he has to undergo for a period of 1 year, the passport authority cannot refuse the renewal of the passport on the ground of pendency of the criminal appeal. The passport authority is directed to renew the passport of the applicant without raising any objection relating to the pendency of the criminal appeal in this court. In this court, subject to the other conditions being fulfilled, the interlocutory application stands disposed of. 2021 SCC online, Miller, page 3549, Supreme Court of India, bench comprised of Miller, Justice L. Nageswar Rao and V.R. Gavai. It is Judge Sahib ke deben?
Page, no, I won't take that page.
3549.
3549, name of the parties?
Name of the parties, Vangala Kasturi Rangacharallu versus Central Bureau of Investigation.
Give me the
Hey,
spelling.
ekটুখানি দিন না, Judge Sahib ke.
Spelling, no, I don't need that. Spelling.
Oh, spell. Vangala, Vangala, Kasturi, Kasturi, Rangacharallu, Rngacharyu, appellants versus CBI, Central Bureau of Investigation. I repeat, should I repeat?
No.
আচ্ছা, আরেকটা জাজমেন্ট কোথায় গেল? এটাই দেখালাম, নাগেশ্বর রাও, এটা দেখাই।
As on date, there is no rejection on their part, isn't it?
Yes, no rejection.
Yes.
Now, I said, Miller, that only Miller, this is, and central government's opinion, my learned esteemed senior friend, Miller, might come up with, Miller, that the opinion of the central government, Miller, as Miller, section 6.2. I said, Miller, that if it is, I was verbally intimated, 29th March is, Miller, if they, it was representation made, P&R P2. But the question is, Miller, withhold a passport.
There is a regulation of the central government. Give that. Go through this.
Now, this regulation has been declared inter vires by a coordinate bench.
Notification.
No, Miller, I said, Miller, there must be an order, Miller, in exercise of the power conferred on section such and such, in suppression of the superstition of the notification such and such, being the opinion of the government, it is necessary in public interest to hereby exempt citizens from being against whom proceeding in respect of whom proceeding against whom proceedings in respect of an offence alleged to have been committed by them are pending before a criminal court in India who produce orders from the court concerned permitting them to India, subject to the following conditions. Section 6.2 also refers here. Section 6.2, Miller, the act section has been interpreted. Then, Miller, kindly the passport to be issued to every citizen shall be issued for the period, if no, for
Prior to going to that, you read out just now, produce orders from the court concerned permitting them to depart. So you have to.
From the operation of, Miller, question is, Miller, I have filed an application for quashing. Miller, FIR was registered.
Then get
Miller,
it done
today,
from that
FIR,
court.
Miller, was only sent with stage of investigation, collection of evidence. So today, Miller, unless charge sheet is filed, now, Miller, question is section 6.2 is the paramount subject of consideration. I will argue on that, Miller, kindly keeps it on Monday in the morning. কেন মা সোমবার কর তোরা তো কুম্ভে যাবি আমরা তো বাইরে যাব
What about the criminal revision?
রিভিশনটা কি আছে পেন্ডিং কি কস করে না দোকান
Get it quashed.
Well, kindly. But kindly,
Urgent basis.
only minute, I have two Supreme Court judgment to show. Kindly take seat up, Millard.
No,
Kindly,
no.
I will enjoy the day at the hands of your lordship, Millard. Kindly take seat up.
There is
No,
some other
no, Millard. No, Millard. No, Millard. Kindly, Millard, decide the issue, Millard.
stored and the
No,
data
Millard.
go over
Millard,
there.
kindly, Millard, decide the issue, Millard.
It is already decided.
No, Millard, kindly take seat up any day, Millard. This is an issue.
You
Millard. Kindly see.
take steps before the revisional court because there is already a decision. I have allowed these type of
But
prayers.
Millard, these judgment of
I
section
have
6
allowed these type of prayers.
allowed.
I have allowed, but even then I'll say, since there is no rejection in your case, your matter is pending before the
Let them,
revisional court.
let them take decision then.
Again, you have to come.
I will come within 7 days. Let them come because they are sleeping over the matter. And my learned senior friend is here, Millard. He is omnipresent and omnipotent.
He has not made an application in a prescribed format.
Oh, there.
He has made a simplicity representation.
Then
And there is a very serious allegation of siphoning of bank's fund of to the tune of 8 crores and odd.
Is it your
Dear Lordship
apprehension?
proceeding.
Is it your apprehension that he will flee away?
He may abscond once he gets it. Beloved, if your lordship, it has, my learned friend is relying on 6 to F. 6 to F has been clarified in this office member.
I have added to Supreme Court judgment 2024. I have not.
Judgment will not prevail over.
If Supreme Court does not matter, then I do not know.
No, Supreme Court judgment will not prevail over statutory provision.
You get it quashed from there. It will be easy for you.
I tell your lordship.
I'll adjourn it for a week. Till March, you have got time. Right? And see, you have not made application in the prescribed format. How can you overcome that? Only a representation is not enough for getting your passport renewed.
Millard, my instruction that I have filed an application for renewal. Millard,
Where
what
is the application in the prescribed format?
That is his representation.
Where is the prescribed format?
স্যার বলছেন যে এটা অনলাইন অ্যাপ্লিকেশন না
Only representation will not do. I can give you leave. I can give you leave to file it in the prescribed format. In the meantime, you can get it set aside by the court.
Yes.
This will also be disposed of. And if your application is made, they'll consider within a prescribed time limit. So another opening is there in front of you.
Only for 1 day time, Millard. Monday কোন না কমবে যাবে একটা কনসিডারেশনের কথা বলবো তার
সুবিধা মতন তো কোর্ট চলবে না
আমার চলবে কেন ঈশ্বরের
Yes. When? Monday? Very well, Monday, not today only. 29.
Deeply obliged. এই বইটা তোর থ্যাংক ইউ ডিপলি obliged.
আমাদের পাসপোর্ট একটা কোথায় গেল?
I am for WVACTCL. Dr. Madhusudan Saharai out of station till 28 January.
I'll fix it on 20.
It is disconnected on 2nd December.
Very well, sir. Wait for 2 more days. Please come. An accommodation has been sought for on behalf of the Learned Council representing CESC Limited.
WVACTCL.
WVACTCL, CESC 9. Stop. List on 29th. Service taken on record. 30.
My lord, I beg to appear on behalf of the petitioner. My lord, I have been briefed in this matter and I have seen that, my lord, an application, my lord, and firearm application was made. And my lord, the authorities has not taken any decision with regard to that. My lord, that will be the only grievance before your lord.
Consideration of your application, page.
Yes, because until and unless a final decision comes, my lord, it's
Page 30, Lordship, 30-31.
30-31. I'm grateful to my learned friend, man. Affidavit of service to রেখে দিন না?
The petitioner has applied for obtaining an arms license in the prescribed format. Date, where is the date?
14/7/23.
It's not appropriate for format, Lordship. Kindly resume page 30.
30 is the format. my lord.
Passport size photograph, there's no photo.
Where is the
There's no
date
photo.
showing the receipt of the application?
That is the subsequent page, my lord, for 14/7/23.
4723. 14/7/20. This is 14/7/23 is a
My lord,
representation.
kindly, my lord, adjourns this, my lord. I will come back with a proper. Yes, my lord. I
Adjourned.
let it, my lord, retain its position, my lord, at least.
Yes, it will be there in the list.
My lord, then a leave may be granted to file a supplementary affidavit. I think, my lord, they have omitted some papers. Kindly, my lord, grants this.
You see whether it is there or not, then I'll see.
Yes, that is there, my lord. There is a
Prescribed format, whether it is there or not.
yes,
Otherwise,
prescribed
I'll
format is annexed, but the date on the prescribed format is missing. That is what, my lord. Annexure P4 is the prescribed format. Application at A1. If, my lord, my learned friend says that this is not there, then, my lord, the kindly takes up annexure P4 at page 30.
do one thing. देखिए file टा देखिए 1 minute.
That
Please
is
come.
the prescribed format.
The petitioner claims to have made an application for obtaining arms license in a prescribed format. Stop. From the documents annexed to the writ petition, the receipt showing submission of the application for obtaining the arms license in the prescribed format is not available. Stop. Next. In view of the above, the instant writ petition is disposed of by granting leave to the petitioner to make formal application for obtaining the arms license if not made earlier. Stop. In the event such an application is on record with the authority, then the same shall be considered by the DM, isn't it? Who is the authority?
DM, Lordship.
DM, district.
Yes, district
And it's
magistrate
or his authorized officers.
Acha, DM or his authorized representative. Nodia, in accordance with law at the earliest, but positively within a period of 12 weeks from the date of communication of this order. Stop. If any document is wanting from the petitioner, the same shall be made known to the petitioner. Disposed. Service রেখে দিন. Next.
For the state.
Lordship, I'm appearing for the petitioner. Lordship, I'm led by Mr. Mukherjee. Mr. Mukherjee is on.
Mukherjee?
Mr. Mayur Mukherjee.
Yes.
Mr. Mukherjee is on his legs, Your Lordship. I'm just seeking for a note today.
Upgraded motion, not today.
Lordship, actually, there's a fixed matter which is going on in court.
No, let the matter go on. There is no difficulty. You can proceed. Yes.
Lordship, I am the one of the residents of this locality, which is in Ashoknagar, Pashwa locality. Lordship, my representation is page number 17, where in my locality there is a liquor shop which is established, and now that liquor shop has applied for a license. Lordship, as per the excise rule, section 8, clause 1, it's Lordship.
Yes.
It states that within 1,000 meters, within 1 kilometer of the area, if there's any school, colleges, hospitals, or place of worship which is there, then a liquor shop cannot be established. However, the liquor shop is established, it's running illegally, and now they have also applied for a license. Lordship, I've made a representation, Your Lordship, but the representation has not been considered. Lordship, I'm just seeking for today, Your Lordship, my prayer for a report that what is my what consideration have they made with respect to the representation which I have made.
Well, first of all, we have not granted any license. It is at the stage of inquiry. Now, that is my instruction. Yes. That is my instruction. Well, because 8(1)(c) says, well, under the rules, the public grievances has to be also considered. So,
the petitioner seeks. Now, the petitioner has filed an objection to the grant of license in favor of the private respondent. Did you serve the private respondent?
Indeed, Your Lordship, I've served.
Where is the service?
Lordship.
Stop paragraph. The same is yet to be considered. Paragraph. Learned counsel representing the respondent authority submits that the application for the retail excise license for sale of foreign liquor is at this stage of inquiry. Stop. No decision has yet been taken in connection with the said application. Stop. Next. In view of the above, the instant writ petition is disposed of by
I'm seeking to
directing
kindly keep this pending, Your Lordship.
Collector of excise, or who will be the excise commissioner?
Well, the commissioner is the highest body. But kindly make it the collector. Sister.
Lordship,
Collector
it's
of
my humble
excise.
request to kindly keeps it pending, Your Lordship. Mr. Lordship, kindly grants one date, Your Lordship. Mr. Mukherjee will argue the matter.
Collector of excise to take a decision on the application made by the private respondent only upon affording an opportunity of hearing to the objectors in accordance with law at the earliest disposed.
Lordship, kindly, Lordship.
He
kindly.
present a instruction to be written with the records. Your instruction is not signed, nothing of this sort. Who has forwarded it?
From the department.
From the department. Yes.
Lordship, then kindly a fresh report be served.
Call the next matter. 42 কেন 32টা 32টা কি হলো? Is Mr. Nondi there?
Yes, madam.
Oh, you are here. I was searching you on the screen. Where is Mr. Chatterjee? The amicus?
Yes, my lord, I have informed him, but
You have informed?
yes,
All right. What will be your prayer today?
my lord, তাহলে কি একটা অন্য দিন তাহলে রাখবেন, কারণ উনি তো আসেননি, যেটা প্রয়োজন বলছেন, তাহলে সার্ভিস গুলো কি নিয়ে রেখে, কারণ 22 তারিখ ফিক্সড করেছিলেন, উনি আসতে পারেননি, আর যদি অনুমতি দেন আমি করতে পারছি, কারণ আমি ফরেনসিকটা বোঝানোটা যে এমার্জেন্সি সেইটা আমি একটু বলতে চাইছিলাম।
আমি তো রিট কোর্টে বসে এত কিছু দেখতে পারবো না।
My lord, I am appealing for item 39 because 32 and 39, my lord.
Stop the live streaming.